I'd like to call the meeting of the Urbana City Council to order. Would the clerk please call the roll?
Alderpersons Ammons.
Here.
Brown.
Here.
Jacobson.
Here.
Madigan.
Here.
Marlin.
Here.
Roberts.
Here.
Smythe. Mayor Pressing.
Here. The first item is approval of the minutes of the previous meeting. We have July 8th special meeting and July 15th, 2013.
Move approval. Second.
Okay, motion by Marlin, seconded by Smythe, I believe.
Yes.
Any additions or corrections to either of those sets of minutes? If not, all those in favor, please signify by saying aye.
Aye.
Those opposed? That motion carries. Are there any additions to the agenda? Don't see any additions. Okay. Next is petitions and communications. I have a number of people who want to speak. Some of them will wait till the topic. Robert Namath. And please state your name
Robert Nemeth,
and address for the
105
record.
East 2nd Street.
Okay.
Thank you. I'd like to just make a couple of brief comments about the historic status of the sorority. I'm for that. I think it should be an honor to have a historic property. My wife and I own a house on the National Register in Champaign and take it as a great honor, not a liability as some people look at historic status. When I look at that building, the sorority, I think there's several words that come to mind: charming, delightful. It's got beautiful detailing to it. And it is a real asset to the community, I think. It'd be a shame to not designate it as a historic property. The historic status still allows it to be modified on the inside. It just kind of limits what people can do on the outside. And even there's, I think, some flexibility as far as materials that can be used for the roofing and things of that nature that I know have been an issue. That's it. Thank you.
Okay, thank you very much. Lee Stoops. Again, your name and address, please, and you have up to 5 minutes.
My name is Lee Stoops, 604 South Poplar, Urbana. I'm the president of PACA. I'm just here to urge you to follow the HPC report and approve the application for the preservation of the ZTA house. I think it's worthy of the status that everybody's been talking about. Thank you.
Okay, thank you. Ken Sallow.
Hi, good evening. Ken Sallow, 611 West Hill, Champaign. I'm here to talk basically about the imminent UCTB privatization. The main point I want to make is to insist for the council to consider retaining the public interest as opposed to the incorporated or privatized, even if it's for not-for-profit. The motivation essentially is, I think, similar to the Urbana City, particularly the mayor's campaign for the remunicipalization of water. I want to argue that information is a key public good that is the essential part of a healthy democracy for an informed citizenship. And the public interest, if we are going to be focused on democratic governance, means that I think the entity to take over should remain within the public domain, so that it falls within the purview of the sort of democratic accountability, particularly right now when marginalized and vulnerable citizens are excluded from information which is crucial for them to participate in forums like that. So I'm arguing and make the same point when I get to Champaign, that the interest is for keeping the public interest, to ensure for healthy democratic governance through informed citizenships. Information is a key resource for that sort of democratic project, similar to the, I think, water issue. Thank you very much.
Just as a clarification, it is still a public entity, so it's not privatizing it. The public will still own the facilities.
Well, I'm really here just to ensure that that public interest part doesn't fall out of the equation in its original genesis, because these are short steps away from for the way I read it, the incorporated status takes it out of, or could potentially take it out of the purview of democratic governance, such as the city council.
Okay, thank you. David Wilkin, I hope is that your name correct?
Wilson.
Wilson, sorry about that.
No, that's
Thank you. My name is David Wilson. I live at 201 Willard Street in Urbana. And just a very quick practical point, and that is that I struggle to see a compelling reason to have the big broadband project turned over to a substantial degree to a nonprofit entity. The nonprofit entities that I'm aware of will very often, they're motivated by profit. And in the process of doing so, what they'll frequently do is pass their costs on to consumers. And we see this in case after case, I think, across our region, across our respective cities. So I think we really have to ask that very important question. In terms of the governance of the big broadband entity, what are the merits precisely, especially the economic merits, of turning this over to, and again to a substantial degree, to a nonprofit entity?
Okay, thank you. Rich Cahill.
Hello, I'm Rich Cahill. I live at 307 South Orchard, Urbana, Illinois. I'm a former president of PACA for 12 years, I guess, and I served on the Urbana Preservation Commission for about 9 years. This house and this should be approved. There's some been questions about, I see staff that was concerned, was it truly Joseph Royer who designed this building or not, or was it Hubert Smith? To me, that's not a real critical issue. Hubert Smith went on to have a very distinguished career. He did a lot of work in Jacksonville, McMurray College, Illinois College, and it did happen that the blueprints for the structure were in Hubert Smith's possession that I recovered, that were in a place called the Ice House over there in Champaign. So now they're have been preserved and are at the U of I archives. The ordinance, that, as it's written, there's plenty of safeguards for the owner. There's plenty of give and take, a whole appeal process. The staff and the chair have worked with numerous properties, materials, and there's a lot of options, so I don't see that being a hardship. The issue of windows comes up quite often, and a number of the properties that have been local landmarks have had replacement windows. And indeed, the one that you passed about a month ago, the Sutton House, has replacement windows. So I don't think this is particularly an economic hardship, and the window and the roof is not going to be the issue that decides if this house gets reoccupied. I urge you to pass this ordinance, and if you see, I have a shirt from Quincy, Illinois, a town not that much bigger than here, and they have over 3,000 properties that are historic landmarks. And why Champaign-Urbana lags so far behind, I don't understand.
Thank you. Steve Burgess.
is Steve Burgess, 1105 East Florida in Urbana. I'm here this evening regarding a resolution that you passed last year, which was 2012-01-005. I know there's an old expression about you can't fight City Hall, and fortunately, we've already been through that process. I really wanted to thank you all. That's why I'm here tonight, because of the discussion that we had last year. I know it took about a month. It was an unorthodox thing for me to appear and for you to have to deal with approving this resolution. For those of you that do not know, this was all an effort that I started about 3.5 years ago to secure federal recognition for my late father, James R. Burgess Jr. And in April of this year, Senate Bill 796 was introduced in the U.S. Senate, along with House Resolution 1707. And to my shock, my dad, time flies, but was elected to countywide office here 40 years ago this past November. Time really flies. And historical footnote, last Wednesday was the 50th anniversary of the March on Washington. I really didn't get a chance to get a heads up at all, but my bill actually was passed out of the U.S. Senate committee last Wednesday and was brought to the floor of the United States Senate last Thursday by Senator Harry Reid, the majority leader. The bill passed. So I thank you all for giving me the support. I also had the support of the county, as you may be aware. The fight's not over yet, and no matter what happens in the fall when Congress returns, I think I got a fair shot of the whole thing. I did get a vote, which is always what I just really tried to do, no matter what happens. So I really thank you all for that recognition, and thank you.
Thank you. David Gehrig.
Because, oh yeah, I'm going to follow that. David Gehrig, 805 South Race. A few years ago when I was sitting in what is now Eric's chair, although not as nobly as he's doing it, Mr. Professor, I was on the Cable Commission, represented Urbana and the Cable Commission and Telecommunications Commission, and it won't surprise any of you to know that I have an opinion on this. I'll keep it brief. It's just part of what I hoped and continue to hope that UC2B will do is help level the telecommunications field. I think that nothing would be more of a sign of failure than if 5 years from now this project was owned by Comcast. I want you to keep in mind that this is something you can only say goodbye to it once. I want you to do it as wisely as possible, with as much as possible, to have the interests of the broad community in your mind for the final agreement. And that's really all I wanted to say, except Hail Fredonia.
Thank you, David. Pete Resnick.
Are you taking comments at time of?
Sure. You want to wait?
Please.
Okay. Fred Westhoff.
Good evening. My name's Fred Westhoff. I reside at 304 North 3rd Street in Fisher. I'm the president of the Firefighters Union, and I'm here to invite all of you to Fire Ops 101 that we will be hosting with the Danville and Champaign firefighters on September 21st at the Fire Service Institute. Fire Ops 101 is an opportunity for community leaders like yourselves to experience firsthand what it is to be a firefighter. If so desired, you will have an opportunity to wear our equipment and perform typical tasks that we do on the fire ground. If you don't want to do that, we still encourage you to show up and observe and ask questions. Some of the activities that we will have you doing is entering a building, smoky building, and doing a search. You get to put out a fire with a hose and assist us on a medical call. I will be emailing each of you an invitation in the near future, and I hope that you can attend. In the past, we've had some, we've done this one other time. Mayor Pressing attended. Charlie shaved his beard for his wife and did it. Mr. Gehrig attended. Ms. Marlin attended also. So I encourage all of you to come out if you can.
Fred, for the record, I shaved my beard against my wife's best wishes, and she didn't speak to me for 2 weeks.
Well, I didn't know she was listening tonight, so.
Eric?
So Naomi did a fire ops and put on the gear and crawled through the smoke and found the dummy and such, so I guess I'd feel like kind of a sissy if I didn't do it myself.
I was kind of hoping you would say something like that. Thank you.
Thank you very much for the invitation. Chris Evans.
Name is Chris Evans. I'm on the 400 block of Illinois Street in Urbana. Thank you again for public input. My understanding is that we built something called Big Broadband for 32 million tax dollars. Your tax dollars, my tax dollars. $32 million were spent. And the reason the Champaign-Urbana qualified for that $32 million was that the project was designed to provide internet service to the poor. There's a lot of rumors going around town, and I don't know if they're true, and I don't know anything about them, but the rumor number one is the poor are not getting service from the Big Broadband. And number two, the U of I stole it. Now, those are two rumors that are going around town. I'm not saying they're true, but to ensure that they're not true and will never be true, I would suggest the following. Number one, that whoever takes over Big Broadband be subject to the Public Meetings Act. Number two, that whoever takes it over has to provide a annual budget report that is publicly disseminated. And number three, an annual report be submitted to the public indicating performance and the areas of service that are being provided by whoever takes it over. Those three things, I think, are reasonably fair since the taxpayers paid for it. So, and to put aside that, to make sure that the poor are getting the service. That's why you got the grant, and that's what should be happening. So thanks for listening, and I hope you can make a good decision.
Thank you. Brian Adams.
My name's Brian Adams. I live at 410 West Elm Street in Urbana, and I'm just here again to support the nomination for the ZTA House in Urbana. And I just would hope that you would all support the nomination tonight. I feel that it's a very, having researched over 150 Royer projects and visited many of his existing structures throughout the Midwest, I think this is among one of the top buildings in terms of its historical revival style and its use of whimsy, which are very typical Royer attributes. So I think this is a very, very unique building amongst all the projects that Royer and his firm produced during his 50-year career. Its location at the south side of the U of I campus provides a nice visual entranceway to the campus town area. So again, I think that it meets many of the criteria set forth in the preservation ordinance. There's no reason why it shouldn't be landmarked. I know one issue that's been brought up is the concern about the windows and maintenance of the windows and making them functional. A few weeks ago, I took a walk through West Urbana, and I did notice at least two other apartment buildings that appear to be contemporary with this building. I didn't research them, but just based on how they look, I assume they're from the 1920s, 1930s. One is on West Nevada, and one is at the intersection of South Broadway and Washington. And both of those buildings have the same type of windows. They're not the sash windows that go up and down. They're the windows that open in and out. And I did take a quick walk around those buildings, and I noticed that they do have the interior screens. So those two buildings, and there may be even more, clearly are using this type of a historical window type, and they're still, since they're apartments, and I assume they meet code, and the city has approved them in terms of their safety, et cetera. And I think the same would apply with the issue of the roof. The particular type of shingles on that building are very, very unique, and it gives it that typical Royer, whimsical storybook style look. And I think that if some research was done, that appropriate replacements could be found, just as was done for the Urbana Lincoln Hotel. So again, I would suggest that you support the nomination tonight, and thank you for your time.
Thank you. Brandon Bowersox Johnson. Welcome back.
Yeah, good evening. Thanks. Good to be here. I wanted to just briefly talk about the UC2B topic. First, I support this transition to a not-for-profit. After years now of talking about the model for this, I think the not-for-profit model is one that can continue to serve the community in the next phase of UC2B. So I urge you to move forward with that concept. I also think, at least from verbally what I've heard has been amended in the agreement in the last week, that it's gotten much better and that the significant community concerns have been addressed. I know the version on the website that I read might not be the final version of the language, so you all should take the time to go through the language and make sure it really does meet the community interests that have been discussed. But from what I've heard, at least, it sounds like we've really addressed the major things that we heard from the community to make sure this is going to serve the public. The last thing I wanted to say was a story. About a year ago this same time, last July, we were talking about what are the criteria for expanding UC2B to serve the whole community. And there was one of these 1-2 meetings where Urbana had a meeting Monday night and Champaign had a meeting Tuesday night, and I was even on city council here at that time in Urbana. And it ended up that after that series of 1-2 meetings that week, the UC2B policy board had 3 different versions of what got approved. And it was then very difficult because Urbana approved one thing Monday night, but the changes that we had made in Urbana didn't get communicated to Champaign the following night, and Champaign approved a different version, and the UC2B policy board met, I think, on the Wednesday and approved a different version. And the way I remember it from last July, we had 3 different versions, and when we went to go put together the RFI for how to expand this, we had to really massage the wording and say, well, what are our values? We have 3 sets of values, this one and this other one and this other one. And that was just very difficult. Well, that was just a statement of our values, but this is a legal document that you've got to get the same between all the entities, and the timing is very short. So I guess I urge you tonight, as you talk about more changes or any more tweaks to serve your values and the community's values, that you ask staff exactly what the process is going to be so that any more changes get discussed tomorrow morning with legal staff from all 3 entities to try to reach a final consensus so that the vote you take tonight and the vote that Champaign takes tomorrow night can enable both bodies to sign off on the same final document. And I know the timeline is incredibly short. The whole UC2B project has had timelines that have been impossible. And that's something that I wish wasn't imposed on us by the federal government, but that's just been the nature of it. So as you discuss any more tweaks, please talk to your staff about how that's going to get communicated so that we don't end up in that situation we did last year, where we're sitting there with 3 different versions of something and really have difficulty moving ahead without a community consensus. So please take your time on this one. It's really important for the future of the project. And thank you all very much for considering and hearing all these concerns and making it better. I think it's already improved a lot. Thanks.
Thank you. Bishop King James Underwood and Reverend Dr. Evelyn Underwood do not wish to speak, but are still concerned about the Dr. Ellis subdivision sewer. Okay. Frank Butterfield.
Good evening. My name is Frank Butterfield. I'm here on behalf of Landmarks Illinois. I'm the director of the Springfield field office, their regional office. And if you're unfamiliar with Landmarks Illinois, we're the non-for-profit historic preservation, education, and advocacy organization working statewide. And I'm here in regards to the ordinance for the sorority house in favor of the designation. And I don't want to focus my comments here on the architectural significance of the building. I think the report that went along with the ordinance provides plenty of detail on the significance and why it meets several of the criteria, and also makes the case about Royer and Smith as well, and the firm as a whole and the significant work they've done. What I wanted to focus my comments on are the larger thematic loss of historic sorority and fraternity houses, both at the University of Illinois and nationwide, and it's significant here at U of I. And these losses have reached the point where a few years ago, Landmarks Illinois considered listing U of I's historic fraternity and sorority houses as a group listing, a thematic listing on its 10 most endangered historic places in Illinois. And it was at the point where the decision was against the listing just because so much has already been lost that it was too difficult to justify that as a thematic listing. So with so many losses already having occurred, it's all the more important that the Historic Preservation Commission, this body, takes the steps to protect the resources that do remain. So to that end, I just wanted to commend the Historic Preservation Commission on moving forward with designating this as a historic landmark, and I hope the City Council does the same, because it's a resource that's worthy of protecting, and it's one that's becoming increasingly rare, and I hope you move forward with the landmark designation. Thank you very much.
You have a question here. Charlie Smythe?
Yeah. Mr. Butterfield, I'm taking advantage of the fact that you're here. Adaptive reuse. If you're concerned about the fraternities and sororities going away or getting demolished or whatever, what alternatives do we have to preserve the structure in some kind of adaptive reuse fashion? What are you seeing out there that works?
I mean, what sort of adaptive reuses?
Yeah.
Specific to fraternity sorority houses? I mean, I don't have that specific case study per se, but I do have plenty of case studies I'd be happy to share on adaptive reuses of historic structures, all sorts of different uses, rehabilitations, using the tax credits, all of those that incentives that helps make these sorts of projects more feasible.
Yeah, well, we have a sort of a unique situation here in that these are, for us, we call it our R7 zoning. It's a boarding house zoning in specific areas. General adaptive reuses that are probably don't apply here. I'm looking for specific examples of things that have been done with this kind of, with boarding houses in general that might work for us, that we would want to consider.
I mean, I would have to have more information to speak specifically, but I mean, continued uses as housing are, most often I have case studies involving that, but to speak on a specific adaptive reuse for, this structure, I haven't seen all of the details to make.
Okay, yeah, I guess. Okay, well, one thought is condos, for example. Okay. Is that being done somewhere with this kind of a structure, or with this kind of a just the concept of a boarding house, moving it to a condo or something like that?
We have transitioned to condos, transitioned to apartments. Things of that nature. I was previously in Wisconsin for 4 years working for the National Trust for Historic Preservation, and have several adaptive reuse case studies that I'd be happy to share with you as well.
Okay, yeah, I'd love that. If you could email
Please,
those to me, I'd love it.
Yeah,
Thank
and
you.
I'll leave my
leave
information as well, too. Thank you.
Thank you very much. Neil Parthen.
Hi, Neil Parthen, live at 705 East Colorado, apartment 105 in Urbana. I'm here tonight because I wanted to applaud Urbana for their collaboration and participation in the UC2B program. Your work to help bridge the digital divide and ensure greater access to high-speed internet is vitally important. And it's clear that the council and the wider community recognize the critical and the very crucial nature in ensuring this program be successful given the time and the money that's been put into its development. I'm here tonight to share my concerns with the recently unveiled proposals. The Council, in conjunction with Champaign and the University, have made positive changes in response to public comment and suggestions, so I do offer these suggestions in good faith. First, I do ask that the ownership of the program remain public and collectively among Champaign, Urbana, and the University. It has been a joint venture so far and should continue. And I would much prefer a lease to the proposed nonprofit than the possibility of having assets transferred to a private operator. Secondly, I ask that a reasonable set of expectations be put in place for the interests of democratic involvement. If the operator or operators of the program would like to take action, it's reasonable that they should have to do so in an open meeting that is accessible to the public of the communities being served by the program. Likewise, as many institutions, it is sometimes necessary that they enter into a closed session. So I ask that it be stipulated that a minimum 2/3 vote is needed for these operators to meet in closed sessions in those instances where they're required. We've made the investment. We need to continue the time, the dedicated, attentive support to make sure this continues, and I'm very confident that you guys will make the right decisions.
Thank you. Peter Folk? Okay. Aaron Ammons.
Good evening. Aaron Ammons, 1108 North Busey in Urbana. I'm here to also speak to the UC2B project. I will admit from the very beginning that I am in very deep water and it's way over my head. So, but there's some basic things that I think I understand about it, and I have some questions. I did watch the very interesting meeting that took place at the city of Champaign, and I have some comments about that. Charlie, I was with you, brother. I was with you. You know. I do want to know what will this new board be bound to as it relates to ensuring minority contracts, the involvement of people of color. And I know that there was some language now that maybe it's going to have the same policy that was there for at least a year. Well, my proposal would be that it should be much longer than a year, because this was about bridging the digital divide and ensuring jobs. And so if it's going to do that, then it should continue to do that for as long as we have it in our control, whether it's as long as it's in existence, instead of giving up the opportunity or giving up the ability to hire and bring jobs to the community, giving it to someone else. And again, I may be over my head in that, but it appears to me that when we have control of it, then we dictate how the jobs are divided. And I would echo, certainly, we loved being able to come to these meetings, to even the long ones, and being involved in the democratic process, having our input be heard. And so we are not, as a public or any entity or any organization that I'm involved with, open to private meetings that would take place outside of public view. And we understand there are some closed sessions, we understand that completely, but we definitely want to be able to see and hear what the body is doing in relationship to the public dollars and the money that we've spent as taxpayers to make this UC2B work. There's a concern to make sure that whoever's on the makeup of this board has at least 3 members from the community at large. We know that there will be, I'm sure, wonderful appointments from the Madam Mayor as it relates to the city of Urbana, but we also think that the people from the community, the average citizen, should also be a part of this. And certainly we think people from the, I don't like to use the word minority, from the black community or other people of color should be on the board. I know there's a lot of talk about Carl Hospital, Madam Mayor's favorite place, I'm sure. And what a non-for-profit will do if they get a hold to this. And maybe, again, I'm just over my head with this, but giving up control of millions of dollars of assets that have created jobs and bridged this digital divide for us to some degree because we're worried about taking care of it. Sometimes I think you just have to go for it. And to give that opportunity or give that to a non-for-profit who can then take it and do what they want to do with it to some degree. Maybe I don't understand that, but that to me means that we're giving up the control that we have of it. And I think that for us to have to pay for it with tax dollars up front and then to have to give it to a non-for-profit who raises the rates and then we have to pay again to continue to line the pockets of some entity outside of the cities, I don't think that would be a good stewardship of our tax dollars. So thank you all for listening, and if there's some clarity that somebody could offer me before I step away, I would certainly appreciate it. Diane, you look like you have some stuff you wanted to share. No? No? Okay. No? Okay. Thank you. Carol?
Thank you.
No?
I think we will give some clarity. Is there anyone else who would like to address the Urbana City Council at this point? Okay, we will move on. Unfinished business. Ordinance number 2013-06-054, an ordinance designating a historic landmark at 1404 South Lincoln Avenue, the Zeta Tau Alpha Sorority House. And we will start with the staff. We're not going to give a report because we've talked about this a lot, but Robert Myers is here for answering questions. So the first will be the nominator. Is the nominator here? Okay. Why don't you come up forward and state your name and address? And you'll be able to, give your speech and then have people ask questions of you.
Okay.
Okay?
My name is Brianna Kraft, and my address is 111 East Provost Street, Lena, Illinois. And I am the applicant of the Zeta Tau Alpha Sorority House to be nominated as an Urbana local landmark. And first of all, I would like to apologize for not being present for previous meetings on the matter. I've been working in Washington, D.C. For the National Park Service for the summer, so I'm happy to be here tonight, and I'm hoping to answer any questions you guys may have about the application. But I wanted to sort of give a brief statement about why I decided to write the application to begin with. It was brought up that I had written it specifically for a grade and for a class, and Alice Novak did address our class offering the topic to be written about. And as a person interested in historic preservation and pursuing a career on the subject, I thought it would be a good learning experience to write an application for a local landmark. And second of all, I have lived in Champaign-Urbana for the last 6 years, attending the university to receive my architecture degree, my bachelor's degree, and master's degree. And I care a lot about this community. I've lived here for a long time, and I like to see that some of the historic architecture is celebrated in the area. So yes, the main reason I wrote the application was for a learning experience and because I support the community and hope that the building could be protected for future generations. I also would like to state that I wrote the application under the impression that Joseph Royer was the architect, and I got that information from Brian Adams' book written on Joseph Royer and from the plans of the building, the architectural documents. And I guess it never actually stated that it was Joseph Royer. It was his firm, Smith, Danley, and Royer. And I would also like to make a case that if it was in fact Smith who designed the building, it doesn't diminish the importance. He, like someone said earlier, he designed several other important buildings in Urbana and worked on others, such as the Princess Theater, and there's a list of them in the packet for tonight. But if it was in fact Smith, I don't think it diminishes that criteria or the importance of that criteria. And my objective for writing the application was not to take away the owner's rights to change the outside of their building, I just wanted to bring it to their attention that they have a special resource on their hands, and that if the building was nominated as a local landmark, the historic preservation experts in the area could aid them in revitalizing the building, and instead of maybe them making a choice that would affect the exterior of the building in a negative way, they could give them advice on how to make changes that will fit nicely with the exterior of the building. So that's all I have to say, and I'm happy to answer any questions that the council or the owners have in regard to my application.
Okay, thank you. Are there any questions from the owner? Okay, we do have one person from the public who wants to speak in favor, Chris Wilcock.
My name is Chris Wilcock, and I live at 710 West Michigan Avenue. I wish to speak in support of the ordinance designating the building at 1404 South Lincoln as an historic landmark. I am truly surprised at the amount of time this council has devoted to the petition, as there has been little argument from anyone involved that this structure isn't deserving of landmark status. Since almost everyone agrees the structure is historic, let me address some of the issues that seem to be holding back the landmark designation ordinance. Objections have been raised to the validity of the petition because it was prepared by a graduate student at the time at the University of Illinois. I would like to point out to the council that the petitioner was a resident of Urbana at the time this request was filed, and there are no age or occupation restrictions in the zoning ordinance that prohibit this valid filing. Ms. Brianna Kraft is a recent graduate of the second oldest architecture program in the United States, a program that has a long and distinguished history of training leaders and experts in the field. She has attained the degree of Master of Architecture, the accredited professional degree that allows for licensure as a practicing architect. Ms. Kraft emphasized in her graduate training the area of historic preservation and is currently employed in this exact field. So the landmark request for this property was prepared by an academically trained expert in historic preservation. There are many members of the local community who would have gladly signed and submitted this request if anyone thought Ms. Kraft was somehow not qualified to submit it, but this doesn't seem fair given that the work for the petition was hers. There have been in the past 10 years several other landmark status requests where the writer of the petition has not appeared before either the Historic Preservation Commission or the council, and has never been an issue until the current property owners insisted they have the right to cross-examine the petitioner. This is not a provision of the ordinance, nor should the council make it so unless they want to erect more roadblocks to the preservation of the unique character of our community. There have been objections to this property that may not have been designed by Joseph Royer. These objections ignore the basic facts of architectural practice and partnership. A few years ago, the university opened a new building, the Business and Instructional Facility, designed by another U of I architecture alumnus, Cesar Pelli. At the time this building opened, Mr. Pelli was 82 years old. It is unlikely that he personally completed many of the tasks his firm was contracted for on the Biff building, but no one would ever suggest that this building isn't designed by him. Royer and Smith were in a partnership, and there's no reason to reject this property as a Royer building just because one of the partners was quoted in a student newspaper article as the architect for the building. That's simply not the way design attribution works. It has been quoted that it's huge that the original owners of this property still own it and object to landmark status. This is factually incorrect. The current owner, an out-of-state corporation, did not assume ownership of the property until 1977. This transfer was done primarily to take advantage of various tax laws. Not long after this corporation took control, the sorority was forced to close, and the cycle of insufficient reinvestment in the property has continued since and brought this building to the sorry state it is in today. The property owners have objected to the landmark status as being too expensive, while they go out and hire the most influential law firm in town to fight a designation they should be proud of. What I see is an out-of-state property management corporation that holds title to a property on a busy arterial next to the university, where most recent building permits have been for 15 to 20-story apartment buildings. I walked by the sorority again this morning. It is clear that this corporation has spent relatively little, in fact practically nothing, on adequately maintaining or updating this structure. It clearly belongs on the most endangered list for the city, the state, or even the nation. I ask each of the City Council members tonight to vote for this landmark status on the merits of the request and on the historic nature of the structure. If you truly believe that this property isn't worthy of landmark status, then vote no. But don't try to hide behind a technicality that doesn't even exist in the zoning ordinance. It is a total red herring to say the petition is defective because lawyers didn't get to cross-examine the petitioner. This is not in the ordinance. If you insist on using this excuse to reject this designation, the citizens of Urbana will see exactly what's happening, that a deep-pocketed, out-of-state corporate client hired the most politically connected law firm in town, and you will find any excuse possible, including making up objections that don't exist in the law, just to do their bidding.
Thank you. Colleen Ramey.
Thank you. First of all, I would like to apologize for my client. Ms. Tamulitis was unable to attend. She was planning on being here this evening, but had a family emergency arise and had to take our son to a surgeon today, so she is unavailable. However, she wishes she could be here. I am here tonight because first of all, I would hope that you all did receive our memorandum that we submitted earlier today. And I just want to review the sort of salient points of that memorandum. At the last meeting, the last City Council meeting, the deadline was raised, an issue regarding a deadline was raised, and that has led us to dig a little bit further into the ordinance and the possible meanings thereof. The provision of the ordinance that I'm referring to is section 12-5E1B, and the pertinent language reads that the recommendation of the Preservation Commission shall then be forwarded to the Urbana City Council for consideration at a City Council meeting occurring within 60 days following the date of the close of the public hearing. Tonight I would suggest to you that this language is ambiguous at best, and it has led us to conclude that there are two possible interpretations of this language. The first interpretation would suggest that the 60 days applies to the council, and it requires the council to make a final determination on the issue within 60 days of the close of the public hearing. Under that interpretation, the City Council is 1 day late for a decision tonight. The public hearing was concluded on June 5th, and now we sit at August 5th, which is 61 days past that day. Under the second interpretation would look at this language and conclude that the 60 days applies only to the obligation of the commission to forward its recommendation to the city, and the city then would have unlimited, would really have no constraints on the time that they took to make a final decision on the merits. I would submit to you tonight that that is that if that is indeed what the correct interpretation of the statute is, that renders this provision unconstitutional. I've explained a little bit further about why this is unconstitutional, but sort of as a brief overview, the idea is that from the time that the application is submitted, the owner is subject to the restrictions that would be in place if the ordinance were to be passed, and therefore is under a temporary designation, so to speak, without a time limit on the eventual length of the consideration by the council. This temporary limit deprives the owner of due process of the law and equal protection under the under the U.S. Constitution, and I have cited a couple of different cases that that support that conclusion. Therefore, we have concluded that there are three options that the council can take tonight. The first is to operate under the first interpretation and consider the
You have
application
1
denied.
minute.
Thank you. Consider the application denied without a vote. The second would be to operate under the second interpretation and deny the application. There have been several issues we've already addressed in previous meetings regarding the reasons why we think that this should be denied, and we stand by everything we've said in the past. The third option would be to operate under the second interpretation and approve the ordinance or the application resulting in an ordinance, and in that case, I would think that we would be on solid ground in an appeal. Finally, I just wanted to mention that we do appreciate the fact that the applicant was here tonight, and we regret that this issue didn't come to light earlier, but we did not participate. May I have just 30 more seconds?
Sure.
Okay. We did decide not to participate in the quasi-judicial proceeding or any cross-examination so as to not confuse the issues. We believe that this issue supersedes the rest, and if you should decide to pursue, to either consider this application untimely, not the application but the decision untimely, or decide to deny it, I would like to just point out that this does give you the opportunity to go back and address the other issues that have previously been identified, as well as clarify this ambiguity in the statute and assure yourselves it's constitutional without pushing through another application under such questionable circumstances. Finally, I would just like to note this application or an application on this house could be resubmitted under the ordinance as it stands in 1 calendar year, which does not, as others have suggested, does not give the owner permission to go out and do pretty much whatever they want with it. They still have to obtain building permits, and so I don't think the situation is as dire as some have suggested. I'd be happy to take questions, and otherwise, thank you for listening.
Okay, thank you. Are there any members of the public who are opposed to the nomination who would like to ask or give input at this point? And I guess finally, does the nominator have a question for the owner, or any questions for the owner? No. No questions, okay. All right. Did you have an additional presentation to make? Okay. Well, I guess we've heard from everybody who wants to speak. So we have the ordinance. Do we have a motion?
So moved.
I'll second.
Okay, motion by Smythe, seconded by Roberts. Any discussion? Eric.
So I'd like to ask Mr. Simon your opinion on whether we are acting in a timely fashion on this day or not.
I believe that you are definitely acting in a timely fashion. I've had a chance to review Council's memorandum where she actually quotes me. Thank goodness she's not the press, because she accurately quoted me, so I thank you for that. I stated, as she indicated, that I had not specifically researched the issue. I have now specifically researched the issue. Council is correct when quoting the ordinance regarding the 60 days, and the key word is consideration. You are to consider the matter within 60 days following the close of the public hearing. The question is, what is consideration? The hypothetical that's been posited that this could go on indefinitely is no longer an applicable hypothetical because you are considering it at best 1 day late, assuming you act today, and that's up to you. If the council were to need more information, maybe about Mr. Royer or Mr. Smith or some aspect of the application or some aspect of the owner's concern, and that information was not available within the 60 days, you would have some difficulty. I believe the reasonable interpretation, given the way the process works, is to at least begin consideration as long as you wrap up that consideration within a reasonable amount of time. And assuming you do tonight, 1 day late, if in fact it is 1 day late, would be a reasonable amount of time. I think any court in the land would find that. In terms of the delegation issue, the one case that was quoted in the memorandum is a Texas state case dealing with a different type of ordinance. There are numerous cases that have held this type of ordinance that we have constitutional. And the primary reason is if there was not a status quo imposed at the time a nomination is made, if an owner had a desire to demolish the building, and fortunately this particular owner has expressed no desire to demolish the building, but if an owner were to demolish the building, they could do so during the pendency of an application other than a status quo stay. Once destroyed, twice lost. There would be no opportunity. The entire proceeding would be moot. So the interpretation, the more reasonable interpretation, with all due respect to my statement last time, now that I've done research, is consideration means acting with some deliberate or within some deliberate, reasonable period of time. I do not believe that an action by interpreting the ordinance as suggested by several has to be done within the 60-day period. In terms of the further delegation issue, the ordinance controls, as well as the bylaws, only for the Historic Preservation Commission process. Here, under state law, an opportunity for both sides has been given to cross-examine each other, and apparently neither side took that opportunity, and neither side asked anyone who spoke in the public if questions. So now you have the application, both sides, and now it is up to you all.
Carol?
I just wanted to ask just a couple quick questions. In relationship to the legal counsel's memo, is there a particular reason why we didn't receive a memo from you in rebuttal to those?
You did. You did.
I received a statement, but not necessarily addressing their particular concerns as illustrated in their memo.
Of the memo that came out today?
Today, yes.
I believe it's not counsel's role to advocate one position or another, plus with the UC2B going on literally down the wire. I think you all received an agreement, which we hope is final, around 5 o'clock today. Obviously, I didn't have the time to draft a counter memo. And beside that, I don't think it would be appropriate for me to take one side or the other, but
I guess
merely to address legal
in the
issues.
question of the 60 days, if the 60 days include Saturday and Sunday,
Yes.
then I can understand it. But if it doesn't include the Saturday and Sunday, then that's where we have a problem, because the ordinance says within 60 days, and an additional day means you're late. So
It does not, the ordinance does not provide for a business day
It doesn't say
count.
business day,
That's
or
right.
it just
So
says
it is
60
calendar
calendar
days.
days. Okay.
But again, the question becomes how you all choose to define, quote, consideration, unquote. Is it some deliberation or is it final action?
Bill?
Yeah, I had the same question about a month ago about the 60 days, but I think Libby's memo cleared it up for me as far as the intent of the ordinance was to forward the recommendation to originally to the next city council. Were you going to talk about that a little bit, Libby, about how this came about, the change? This was just 2 years ago, I guess, when the ordinance was changed.
Yes, and that was an attempt to clarify earlier language, but I do want to remind everyone that this is zoning ordinance, and we have by law designate to administer it and to interpret it, and that's your zoning administrator who's here. And I have been administering our historic preservation ordinance really since it was adopted. And Robert's our historic preservation expert, and so the staff assist, and we wrote the language, so I think we understand what the intent, and it was written with assistance, legal assistance. So the operative word is forwarded, and that's what we have followed in other cases. I would also, so it was forwarded within the 60 days, well within the 60 days. I would also note that nowhere else in the zoning ordinance does it talk about timelines for conclusion of decisions. And we do move things through quickly. We've had 2 landmarks that were held at the council level within recent years. One would be the Urbana landmark and one the Halberstadt House. And this was while council deliberated and there was a change of ownership during that time period. So we have never operationally used the 60 days to be the end point, just to ensure that things proceed in a good manner from commission to the council. And I think that we've done that here. And again, having written the language, the operative verb was forwarded. At the last meeting, council did ask for some clarification of the language. We're prepared to do that in our next amendment. If there are concerns about how we've been interpreting this language, we have a process to challenge that. Anybody can appeal to the Zoning Board of Appeals interpretations. So I think that City Attorney's made some excellent points tonight about the process so far, and I just wanted to add in the zoning administrator's viewpoint.
And, you want to say something else?
To follow up, I just wanted to, for the benefit of the people that didn't get your memo, before it was amended 2 years ago, the Historic Preservation Ordinance said that they had to forward it to council at the next meeting of the City Council. But then 2 years ago, it was amended, and a part of that too was to also that the owners would have to be mailed a copy within 15 days prior to the meeting. So it often didn't work. So they changed that. Instead of saying the next City Council meeting, they said it had to be forwarded within 60 days. And so it's clear to me that the intent was just to delay the forwarding, to allow notice, better notice, not to demand a decision within 60 days.
Anyone else? Diane?
Could someone clarify the chain of ownership of this property? I was under the impression that the original owner was still in possession.
Yes, originally the property was owned by the local chapter of Zeta Tau Alpha, and at some point, I believe in the 70s, as was indicated, the structure of the organization changed from having each individual chapter own their own building to having a the national group own all of the properties, and at that point. Title was transferred to the National Housing Corporation, who has been represented here in all of these proceedings. And that being said, it's owned by now an affiliate of the original owner and arguably one body, if that makes sense. And if I may, could I just clarify one thing that was said earlier?
Go ahead.
It's not our contention that in this case, the council has taken an unreasonable amount of time. It's or that having such a temporary restriction on the use of the property is in itself unconstitutional. What I would argue to you is unconstitutional would be having such a temporary designation that has no outside time limit specified in the ordinance. And that, under the second interpretation, is precisely what we would be dealing with here, regardless of whether or not there are time limits for decision in other parts of the ordinance. If you, I do agree with council that there have been other similar ordinances to this that are constitutional. The key issue is whether or not there is an outside time limit on action by the city council, by the ultimate decision maker to take action, and whether it be 60 days or a year, or that
Okay.
can be debatable. What is an appropriate time limit?
Yeah, I don't think that we're debating the constitutionality of the ordinance. We're just going to vote on this, and that can be decided elsewhere. Anyone else?
Thank you.
Okay, would the clerk please call the roll?
Alderpersons Ammons,
No.
Brown,
Yes.
Jacobson,
Yes.
Madigan,
No.
Marlin,
No.
Roberts,
Yes.
Smythe,
Yes.
Okay, was that 4 yeses and 3
and
noes?
3 noes.
Okay, so the ordinance fails because it requires 5 votes. Okay, thank you. We will move on. We have reports of standing committees. I don't believe we have any. Reports of special committees. Did you have something you wanted to do, Dennis, or not?
Yeah.
Okay.
We do.
You want to put it till later because we have a lot of people waiting for
No.
UC to. Okay, go ahead.
If we do it at the end, nobody's going to care.
All right.
Okay. So as you know, several people have gone, 6 people traveled to China over the last couple of weeks. It was a sister city visit, and let's try to get this thing set up here. We're going to walk you through our experience as a sister city project. And of course, you realize that we've been developing a friendship with the city of Guangzhou in China, in southern China, and specifically the Haizhu district, which is about 1 million people. It's a smaller district within the larger city. Our interest is, my interest as the chairman of the Sister Cities Committee, is to promote the success of a grant project that we've been given from Sister Cities International. Right now we have a $100,000 grant to do some work on solid waste and composting, and to do processing of and collection of materials and separation of solid wastes in Zomba. And part of that grant is meant to engage a third city to help us in China, because of the interest in cross-referencing and having a discussion between different kind of community backgrounds on how to solve these environmental problems. So we've traveled to, here, let me try to make this full view, full screen mode, and so Guangzhou is in southern China. Here's a map. And on our journey, we went to Guangzhou, we went to Shanghai, Xi'an, and Beijing, but really the focus of our trip was in Guangzhou. We flew into Hong Kong and arrived, and we spent a day in Hong Kong. We looked around the city. We took the ferry across the bay, took a bus to the tram, took the tram to the top of the mountain, had something to eat, and came back down again. So we used 3 different kinds of transportation, plus we walked. In the evening, we started to experiment with Chinese culture. We went to a restaurant, and we decided, well, this is a city that enjoys fresh fish and often serves it, and so we were told to go look at a fish. So we picked a fish out, and unfortunately that fish demised itself in about 5 minutes, and it was on our plate in about 15. I have to say I did feel a little bit sorry for the fish, because I did look him in the eye before we ate him. Here's a night scene in Hong Kong. They have a lot of signs. They love neon lights. It's kind of a happy and colorful experience in the downtown. We arrived the next day via train to our destination, which was in Guangzhou. We met our representatives at the trains. They're very kind and generous to us. We moved into our hotel. And that afternoon, pretty much right off the bat, they took us to the most significant thing in their city. It is called the Canton Tower. It is a modern structure that's only about 10 years old. It is the third tallest structure in the world. At the top of the tower is, of course, exactly where they took us, and we found that, what do you know, there's a fun ride. It's a bubble car. The bubble tram is there's perched on the very edge of the abyss on the third tallest building. We get into these little bubble cars and they circle the edge of the building, and it takes about 20 minutes. It was pretty exciting. Then we went down to a lower level and we were able to send a postcard home from the highest post office in the world. The next day we went to, or actually that afternoon, we went to a very interesting thing. They called it the Swamp Park. Actually, it was a wetlands project, beautification project, which they installed in a 3-year time zone. And this park was, I don't know, like 100 acres. It was gigantic. Of course, it's near a river. But the incredible thing was that they completely planted and landscaped this park, I would say, like practically overnight. And we got out and they said, well, you know, recently the city of Guangzhou had hosted a world competition on environmental sustainability projects and innovation from municipalities. And all the cities that participated in that event were recognized by having a tree planted in their honor. Well, Mayor Pressing and our arborist had made an entry in that competition. And so our task suddenly became find Urbana's tree. And luck was with me, and after looking for about 10 minutes, and must say that I didn't go for the middle of the tree lot, I decided to skirt the edge. And there, next to the sidewalk, was Urbana's tree. Chirorisa speculosa, which means it is a silky floss tree, has beautiful pink flowers in the spring, but it has thorns on its trunk, just for protection, I'm assuming. We were number 111 out of 153. So we found our tree and we took a picture. Then we went to a local historic museum and learned a little bit about the rise of the small fishing harbor on a sleepy stream near the ocean, and how it became a bustling center of commerce that commands so much trade and commerce today. This was the old Canton. It was a port to which the Portuguese and the English were able to come to trade, and became quite it was really the beginning of the modern commerce in China. The next day was a Sunday, and we were very happy to meet up with Kathy Ha, who visited Urbana about, 9 months ago. She is in the Police Administrative Bureau of Haizhou and Guangzhou. She lives in Haizhou, actually, but she, I think, works for the city of Guangzhou. She had come to Chicago to take courses in trees and police procedure. I had come down to look at the police, Urbana in the U of I Police Training Institute, and spent a day with Chief Conley. And we enjoyed having dinner with her and meeting her at that time, and she was from our sister city area, so she was very kind and said, if you ever come to China, please look me up, and I'd love to show you the city. And indeed, she did. She spent an entire Sunday hosting us, and we went to various places. This was a cultural, it used to be a home of a clan home, the Chan clan, and it's now an art museum with folk and local arts. We spent some time there. And then she took us over to see the memorial hall dedicated to Sun Yat-sen. It's an assembly building, kind of like the Follinger Hall on campus, the circular building. It's got a large auditorium inside and a statue to Sun Yat-sen on beautiful grounds. Probably the highlight of the day turned out to be our evening experience with Kathy. We took the Pearl River boat cruise. She invited us to do so. We had heard about it, and I think we've discovered it to be far beyond our expectations. The entire river's front for like about, 7 miles, including all the bridges and the major buildings, are illuminated at night. And people board boats and they float on the river. And as you go down the river, here's one of the tallest buildings in the world is turning into a colored popsicle in front of your eyes. And the bridges are all illuminated, and we had a nice meal on the boat. And the boats that are drifting by us are all neon lit in various wild colors and patterns. So it was a lot of fun. The next day, however, we actually had some real business to deal with, and we had an opportunity to meet with the city staff in Haizhu, including about 10 members, many of them of the Foreign Secretary's office, and it was led by Mr. Zhang Yo, who is the Security General and a Communist Party leader for the Guangzhou Communist Party, and represented the area. So having him present was quite a feat of goodwill, because he's one of the decision makers whose word must be listened to. We watched a 7-minute program on the success and growth of the city, focusing on commerce and the new building that's going on at the city. And then we were able to give about a 10-minute presentation on our Sister City program, our interest in sustainability, the interesting fact that we have partner interests with them on dealing with solid waste issues and reclamation of raw materials, and also there was a discussion about river dredging and water and sediment use. At the end of that, and if you noticed in the previous slide, there was a gigantic banner as long as the building, welcoming us to their city, calling us distinguished guests, and certainly we did feel pretty distinguished. Afterward, we shared gifts. We gave them the booklet that was prepared, published in Chinese language, on the history of our Sister City projects, and we gave them books about the history of Lincoln, time biography of Lincoln that was very nice, a book by Larry Canfor with pictures of the area, and some coasters from the Lincoln Library and Museum in Springfield that had quotations on them from Lincoln dealing with friendship and the importance of friendship. This is the book that, this is open to one of the pages in the book, and you can see that it had been translated into Chinese, and we had it printed locally, and we took it with us, and it was very well received. They were pretty impressed that we had taken the effort. At the end, Christopher Storr, who's the manager of our program, gave Mr. Yao a letter from the CEO of Zomba, Malawi, an invitation to visit Zomba to participate and discuss matters of the project that they're working on, and to look at the city and become familiar with African culture. And so that was, I think, a very special opportunity for them to think about participating in our work and visiting a completely different continent at the same time. Here's a picture of the Chinese I found were kind of interested in group shots and group pictures, and so we all lined up under the banner. Took a shot there, and we also did the same in the hallway. They have an immense city building with a 2.5-story carved mural. Fantastic. And afterward, what we do, we went out and had a really great meal. And it was one of those never-ending courses of food served on Lazy Susan. There were toasts given for friendship and goodwill, and gifts were shared. We all received a picture of Canton Tower at night in a beautiful frame, and as a token of our sister city programs and their participation, they received a beautiful crystal globe. And it was during this banquet that we found out that we would have permission to do an exchange between China and Africa as far as cooperating on the grant program. And so we have our first exchange scheduled tentatively for early October. What did we do after we ate? We immediately went to a solid waste processing plant and watched human sludge being turned into pure water. And actually we went to two. And of course, this was part of the thing that we're interested in for our grant.
Yeah.
And there was a beautiful sign on the door of the plant. This is one of the biggest plants. This is a gigantic plant, and it processes solid waste for 141 square kilometers and 2 million plus citizens.
Dennis, I think we're going to have to cut it at this point. Because we have a lot of people waiting to talk about UC2B.
Okay, well, all right. I'll make a very quick, I'll just run through the pictures. We visited Sun Yat-sen University and met with the geology department. And this is just some of the people who made our trip so enjoyable. And that is the presentation that I prepared.
Okay, thank you very much.
There's more later.
We'll save part 2
Okay.
for next week.
We'll do part 2 next. Okay, let's move on then. Let's skip reports of officers and the mayor's reappointment and go right to ordinance number 2013-08-065, an ordinance approving, authorizing, entering into, and executing a second amended and restated intergovernmental agreement providing for the creation of the Urbana-Champaign Big Broadband Consortium, authorizing the creation of Urbana-Champaign Big Broadband Incorporated, a not-for-profit corporation, to undertake the next phase of the UC2B project following expiration of the federal grant. And you want to start with the staff presentation? Okay, go ahead.
I'm joined by Terry Legner this evening. Thank you for joining us. She has been basically the guiding force behind UC2B operations. The document I sent you at about 5 o'clock this evening appears to be, at least as far as the 3 attorneys are concerned, a final document which we are recommending to you all, as well as the Champaign Council, tomorrow night. As you all know, and from your meetings with me one-on-one, as well as the July 30 presentation, has been the end result of months, weeks, hours, days of work among the 3 attorneys. It has not been a simple process, I can assure you that. Defining who owns what pretty much came down to today. And many of the concerns that have been raised in terms of openness and what happens to the assets in the event the not-for-profit fails have been, I believe, addressed per yours and the Champaign Council's desire. The concept of a not-for-profit, as you know, is found in the business plan. It's always been provided for, and obviously we have taken, as attorneys, your and University of Illinois and Champaign's direction. In terms of openness, a lot of changes in the bylaws, which were sent to you, I guess a week or so ago. What we think are the final, with one exception. Mayor Pressing asked for a change in the purpose statement, which appears at section 1.2A, and rather than being for the relief of government burden, it will be more for, it'll be drafted as public interest. In terms of openness, the board, pursuant to the most recent draft of the not-for-profit bylaws, provide that annually a meeting schedule will be published, which will include regular meetings as well as an annual meeting. The presumption will always be that meetings are open. If there's an effort to close a meeting, a statement in terms of why the meeting should be closed must be provided. There is a provision for conducting or taking action by written consent, but again, addressing concerns of both councils. That has been limited to pretty much emergency situations. A node blows out on a Sunday. There's not a chance to call a meeting because people are out of town, and yet some action has to be taken right away to restore services. That's the kind of action that is contemplated, and it would be thereafter ratified. In terms of the assets, that has always been the hardest problem, because this UC2B, I'm going to call it that because the system is a defined term, but UC2B is a collection of legal interests, which are very hard to define, and some of these issues are unfortunately ahead of where the law specifically is today. There is the system, which consists of what we would euphemistically call the hard assets, fiber in the ground, the connections with the building, and of course there's software that runs this. There are other assets, such as the contracts and the subscription agreements, as well as liabilities. Through the process, and obviously I'm relatively new to the process, I've come to learn, and you all probably also are aware, that the university does not want to run the system unilaterally. Champaign does not want to run the system unilaterally, and the cost to do so will, especially because we're talking not just running the existing system, but trying to bridge the digital divide throughout the Champaign-Urbana and ultimately even part of Savoy community. Obviously that includes university property as well. And it has been stated, I believe, by Mr. DeJarnette that such a process could be upwards to over $30 million. I don't think any of the three of us singly or jointly have that kind of money available to do further build-out. It is hoped that the not-for-profit, which will be the next step in the consortium, will be able to do that. I assume in the business plan when it was drafted, a determination was made that it would be more efficient to run this by a single entity rather than a committee that we call the consortium. It's also hoped that at some point UC2B generates revenue that can come back to the university and the cities to be used for the public interest. There are no members, there are no shareholders, and therefore the concern about profit generation is minimized, if non-existent. Obviously, one of the hurdles that's going to have to be cleared is, yes, revenue will be generated from the operation of the system. That revenue has to be larger than the costs of the day-to-day operation, because at some point the hard assets will begin to break down. The federal government gives the fiber a 20-year life expectancy. I don't know whether that in fact is true or not. Some of the other assets have a 7-year life expectancy, and at some point, they're going, some of these assets are going to have to be replaced. The hard assets, we call or define the system, are not going to be transferred. But certain rights to use the system will be transferred to the not-for-profit, and a sufficient nexus of rights has to be available so those who want to purchase IRUs and want to connect up to the system and expend whatever it takes to connect up to the system have an incentive to do so and are not operating under the fear that at some point their rights and connectivity will either cease or be seized by an entity. In other words, to make this thing marketable, there has to be a certain level of rights to use the system. So if the not-for-profit were to dissolve, there are no hard assets that come back to the consortium or the entities because they haven't left. The consortium remains in existence because of that, albeit somewhat dormant, if you would agree with that. And it would be reactivated, so to speak, in the event the not-for-profit were to dissolve. And then the consortium would deal with the issue. The other rights that have been conveyed, the rights to the contracts and the subscription, they all would come back to the consortium, and the consortium would have to address the issue, now what to do, recognizing that for some reason the not-for-profit failed. And who knows why it would fail? Let's hope it doesn't. Nobody's expecting that to get done. The hope, if you approve this, and if Champaign approves it, and I believe the Chancellor for the university has indicated that the agreement will be approved, is to take the next step to form a not-for-profit. The details of a lot of the bylaws were discussed at the July 30 meeting, so I'm not sure it'd be productive to rehash that. If Terry wants to chime in, she's certainly welcome, and Mike Monson, he's certainly welcome to chime in, and we can answer questions.
Okay, any questions at this point?
Sure.
Charlie?
There were substantive changes to the bylaws after the joint meeting last week. I had the opportunity to read those. I left my copy, or the copy I was shown, in Mike's office, assuming we had an electronic copy or we'd get one. Has anyone got an electronic? No, we have not received an electronic copy of those, let alone a printout one. I'd like to call a recess for the length of time it takes to get an electronic copy of the current bylaws as they stand. I'll settle for electronic. A show of hands for those who need it on paper. Anyway, I'd move for a recess till we get those.
A second at recess.
Well, sure. Yeah, we can keep asking questions while we get them. Sure. Yeah.
Okay, we want to make sure that the right version gets to Champaign, for one thing.
Right. The bylaws we don't have, but we have the IG.
I probably have it upstairs if you'll allow me to recess along with you, and I'll run upstairs and shoot it out to everybody.
Okay.
Okay.
5-minute recess then?
We'll have a recess for 5 minutes. Okay, are we all set to continue them?
I believe the bylaws that were in the council packet are the most recent version, with one exception. When I sent you all a minute or two ago, I did include Mayor Pressing's requested change that has been agreed to by both Champaign and the university, and you'll find that in the bylaws. At section 1.2A, we've changed to relieve the burden of government that to provide for the public interest. The relieving the burden of government language was found or was taken originally from the business plan. One other correction that was just brought to my attention: on Exhibit A, which is the list of policies and the reference to incorporating the policies into, that's the policy committee policies, or UC2B policies, into the bylaws, is found at section 4.1.6, paren C. And then it refers to Exhibit A. which is a list attached at the back. About maybe a third of the way down, there's a reference to 2012-12, a resolution approving wholesale and dark fiber services and rates. That actually should not be in there, because what happened when that resolution was considered is it was broken up into 3 separate policies or resolutions, and they became 18, 19, and 20, correct?
Yes.
So, in essence, 12 is kind of repeated in 18, 19, and 20. So what you have are, at least at this point, the final bylaws, which would be attached to the second amended intergovernmental agreement. It should also be noted that the second amended intergovernmental agreement, most of it has already been approved by the council in the form of the first amended intergovernmental agreement. What is provided here that is different is principally 2 things. One, authorizing the creation of the not-for-profit and its bylaws, and some provision of what should be generally contained in those bylaws, and then what happens to the assets in the event of a voluntary dissolution on the part of the not-for-profit. Obviously, we addressed the situation with the transfer of the, quote, system, the hard assets. There will be no transfer, but merely a right to use and connect up to the system. And then what happens should, it's also provided in the intergovernmental agreement, the latest version that you received this evening. Yes?
The version that you sent still says the burdens of government.
I can't hear.
The version that you sent still says to relieve the burdens of government.
I just changed it.
Okay.
It will.
Well,
It's going to. If it's the July 31st one, it will say the language that you recommended.
To promote the public interest?
To promote the public interest. It should say. It will say that.
Okay.
I put it in there, but maybe it didn't pick it up when I sent it on to you all. But it'll be in there. In fact, I've made the change on my draft already. The final thing is the timetable. I think Terry can address that in more detail if you want to explore that. But we have to submit what I would call a pre-application to the federal government approving our next step, because they want to know what's going to happen with their interest. They will retain an interest in the assets for the life expectancy of the assets. In the case of the fiber, as I indicated, that would be 20 years. We require their approval, we being the not-for-profit or the cities and the university require their approval if we do something different than what is applied for. I call it a pre-application because there'll be some give and take by NTIA, and ultimately we'll arrive at what should be contained in the final application. That will be submitted by August 29, is that correct? And then NTIA has until, well, hopefully by September 30, because that's when the grant runs out. If this is not approved, if our application is not approved by September 30, the process has to start all over again. It's more complex. The people administering the grant probably will be scattered to the 4 winds of federal agencies, doing other similar things, and just tracking down the right person, both at the state level and at the national level, federal level, may take some time. In the meantime, the cities and the university continue to fund UC2B, and it would continue to operate just as it is. And that's where we're at.
Okay. Any questions? Bill?
I guess just on the federal interest in assets, it's never been real clear to me exactly, is it just a controlling sort of interest, or do they actually have a financial interest as well? Like
They have, well, I'm not sure what you mean by controlling. They have roughly a 77% ownership or lien right interest in the assets. That means any effort to dispose of the assets other than what's been approved in the application must receive federal approval. Because the university is involved, there may be some state approval because the assets, the hard assets, are not being transferred. University can't just on its own transfer assets. It has to go through a process through Central Management Services. So do they, quote, run the not-for-profit? No. Does the not-for-profit have to get approval from the government if the overall application process is to be altered? Yes.
So I guess just how that might play into some of the things that have been discussed about potential disposition of assets. We don't really own much, really, as far as the assets go. It sounds like the consortium or the nonprofit. We talk about $33 million invested, maybe resulting in $25 million worth of assets. The federal government owns 77% of that. And then presumably there will be intellectual assets coming around at some point, and assets involving customer lists and things like that the nonprofit will own. So there's assets there, but when we talk about disposition of assets, it's just I'm trying to figure out how much assets there are really.
The assets are owned by the consortium, the hard assets, but the consortium is basically a committee. It is not a legal structure like a corporation or like a city or like a university or like a not-for-profit corporation. So the assets were purchased with the grant funds. The university applied for the grant, obtained the grant, and then the cities became through subawards, built out the rings and the connections as they exist right now. But ultimately, including those assets, call them soft assets, that are transferred to the not-for-profit, should the not-for-profit elect to voluntarily dissolve, those assets all come back, and the consortium becomes vested in those assets, as well as they already have system assets. And then a decision is going to have to be made by the three entities or whoever's left in the consortium at that time should an entity withdraw. Champaign would hold the assets in trust, should they come back, hold the assets in trust for the members of the consortium. A trust imposes certain fiduciary duties on the trustee, Champaign, to hold them and maintain them and preserve them for the benefit of Champaign, the University in Urbana.
Dennis.
Yeah, that touches on one of my questions that I had. So if the nonprofit folds or decides to de-invest itself, and these assets and the responsibility of maintaining the subscriber services returns to us, and what is it that guarantees that the consortium is actually still going to be there? That it's sustained in absentia during the 5 years or 6 years or 4 years that the nonprofit's holding it. You just mentioned that potentially one of the members would not be interested in returning to membership in the consortium. So does that then allow the remaining members to hold controlling interest? Does it become sort of privatized back to the municipality?
Well, I wouldn't say it was privatized back, but it becomes, the assets revert to the consortium, and if there are two members of the consortium, then the consortium operates the system.
What if there are no members? That there's nobody who wants to pick
then
up
Champaign holds the assets in trust for the three members, and if none of the members, former or then current members, wish to operate the consortium, then a decision has to be made by the three entities on how the assets are disposed of. That's kind of the end of time game, and we don't know what the law is going to be at that time,
right.
And we don't know who's going to be in the consortium at that time.
Right, and it's kind of an interesting question to ask because to sustain the services, it does require a pretty significant build-out still, which is a kind of a challenge, in a competitive world to successfully do that. So
Well, the same
we have
situation.
it's like a half glass full, half glass empty.
The same situation exists right now. Any one of the three members of the consortium can pull out of the consortium, and if they all pull out, at some point, there's going to have to be a disposition of assets, or everyone walks away from the assets, or we have a Google situation, I guess it was Kansas City, where the assets are sold for $1. Provo? Was it Provo? And yet, in that case, I believe there were bonds outstanding, and Provo continued to pay on the bonds, even though they didn't have the system, because they sold it for $1. We would hope that we learn something from that less than stellar example.
Okay. Anyone else have a question? Eric?
Yeah, I'd like to move from the consideration of what happens if this fails to what are the ground rules for making it succeed. And if I'm understanding this correctly, this will provide, of course, the governing board can do whatever it wishes to do. But assuming that we appoint the governing board wisely, they will, we assume that they will want to uphold principles of open access that we've discussed for a long time. And so there's nothing, as I see, in either the bylaws nor in the intergovernment or in the inter-unit agreement that compromises the board's ability to do that. That is, in other words, we hope we're going to appoint people who are not going to give a commercial enterprise such as Comcast or AT&T exclusive domain over some part of the fiber network. But they could do that, but presumably we're not going to appoint people who would do that. Am I understanding this rightly? We do lose control except by virtue of the types of people we appoint. Is that true?
Partially true, but partially not true. The not-for-profit board does not have exclusive province over every aspect of the operation of the corporation. The bylaws, as they are currently drafted, provide that the not-for-profit board, for instance, can't change how people are appointed to serve on that not-for-profit board. That is frozen in stone. It remains with the three entities unless an entity drops out. And then their appointees serve to the end of their terms, and then the board drops down to a 6-person board. Another feature in the bylaws is that the not-for-profit board cannot change the dispositional structure regarding the assets. They can't decide to sell the assets at any time to AT&T, as you suggest, or Comcast. The assets remain with the not-for-profit, and if they choose not to want to continue operating, the assets come back to the consortium. That cannot be changed. The Not-for-Profit Act allows us, or allows you, to put in place certain irrevocable sections of the bylaws. Those are the two principal irrevocable sections. In terms of following policies, there's a provision that the board will follow the policy committee's policies for a year. The one thing you don't want to do, because given the reference, I think by you, Eric, of competition, or somebody else by competition, this is not the sanitary district. This is not Ameren, in essence. This is not a monopoly. So they will not have monopoly power, and will not be, and obviously are not already, the sole game in town. It is a competitive, albeit not-for-profit, a competitive entity, and it has to operate lean, green, and mean, and efficiently to be competitive. If it stops doing that, then the not-for-profit will have a problem. I think your underlying concept always is true, and that is this thing will be only as strong as the people we appoint for our members, for Urbana's members, and who Champaign and the university appoint. From my understanding, a number of the people that will be appointed, I don't know who our appointees are going to be. You all will provide the mayor advise and consent on the 3 appointees you select. But to my understanding, Champaign and the university are going to appoint at least 1 or 2 each, people who have been on the policy committee to maintain a continuity of institutional knowledge about this.
Did you want to say anything, Terry?
I'm sorry, Mayor. I wasn't understanding the question or the comment you were making.
I thought that the new organization couldn't just do anything at once. It's constrained, and it couldn't get rid of the assets or just get them all to AT&T. But I wondered if you had anything you wanted to say before we go on to the questions from the audience or comments from the audience.
The only thing that I would add that Eric raised earlier, the issue of expansion and open access and fiber construction, et cetera, that is a policy that not only the member entities have adopted, but it's also a policy that runs with this set of bylaws in the intergovernmental agreement. It references things like open access, so that prevents this from becoming another Comcast system or another AT&T system. It references 100% fiber build-out. It can be enhanced with other wireless services or things like that, but it provides for 100% fiber build-out in front of every property in the Twin Cities and Savoy. So there are more details to that policy. You all have seen that and adopted that before, but I thought it was relevant to the point that Eric was raising earlier.
Charlie?
But to follow up on that, Terry, it's my understanding those policies are only in force for a year, or is the assumption that the NFP can, and for NFP is not for profit. You're going to hear NFP used a lot tonight. The NFP is going to adopt these isn't necessarily going to adopt these policies. They're not bound to adopt these policies. They're just simply bound to them for a year, right? Yeah.
Yes, and the reason that was stated the way it was is the not-for-profit has to have some room because it is an organic entity. The bylaws are a constitution. They can be amended like a constitution, but most organizations don't enter willy-nilly into amending their bylaws. The organization needs a continuity because of the complexity of this project and this system. The organization also has to apply for tax-exempt status, which is separate from not-for-profit status. And so some of the policies in there, or some of the provisions in the bylaws, for instance, are to enhance that. But at some point, the board is going to think or rethink, if necessary, a policy so it can remain competitive and operational and do that which it's intended to do, which is to build out and operate the system in an efficient, competitive manner.
So let me follow up on that. I've got a couple of questions here for you. The policies, though, do they expire automatically in 1 year, or do they continue unless they're changed?
They continue.
Unless they're changed. Okay, good.
Their obligation is to follow them for a year, but they don't expire. They adopt them, and until they elect to change them, they remain in effect.
So, assuming the provisions for openness that we've got in here work, then we'd at least any changes would see the light of day.
Well, the openness provisions that are built into the bylaws are bylaws provisions. They're not on this list of policies.
But what it says, if they were to change policies, they would hopefully be seen in a meeting, and et cetera, down the road. Okay, so let's jump into 9A2 in the which is the transition to not-for-profit. That's the major new section in the intergovernmental agreement. And first, I should apologize. I was looking for newer bylaws than the ones from the 31st. And the 31st ones were in the packet. I did read those. I did leave my written copy in Mike's office on Thursday, but but I thought there was something newer, and there wasn't, so sorry about that.
I will say in my haste to get down here, I did not bring with me, unless Terry has it, the latest, greatest version of the second amended agreement. But I know, I'm familiar with it.
It's very simple. Okay, so it talks about Exhibit C in which are the bylaws. Which one is Exhibit B? Is that the business plan? Exhibit A is the policies, Exhibit C are the bylaws, but I don't,
I believe the list is on the back, at the end of the intergovernmental agreement. I haven't memorized
there's the budget summary.
Exhibit A is the preliminary startup budget, Exhibit B is the transition budget, Exhibit C is the proposed not-for-profit bylaws.
Okay.
The business plan is not an exhibit to this.
Okay. This is just a comment. The 9A2 talks about corporate limits of Savoy, Urbana, Champaign, and university property. There's nothing in here on pieces of the network that cross the county. Are there absolutely nothing that crosses county or county right-of-way?
That I couldn't tell you because I don't know what the university boundaries are.
Yeah. So, yeah, I don't know how the university and the county right-of-way, I don't know if that's been left off of here, but Mike might know.
Everything we've talked about in terms of where fiber to the home would go would be within those corporate limits. There
Okay.
are parts of the rings that are in unincorporated parts of the county, yes.
Okay.
But apparently they're all within the county.
Yeah, well, the thing is, I didn't know if that need to be mentioned in 9A2, just, that there are pieces outside of these corporate limits and the university boundaries. That might be something you might want to look at. It may be totally trivial. Going to the bylaws, 5.3 is the section on electronic attendance. And I had made a suggestion at Tuesday night's meeting about how to improve that, particularly with respect to the public. And I remember there was a little language in there. It was a one-sentence thing, and it suggested that attendance by by electronics was totally acceptable as long as that it provided that all participants were able to participate, including the public. Currently, it says participation in such a meeting. By means of which all persons participating in the meeting could communicate with each other. Do you take that to mean the public as well?
Yes.
Okay.
I mean, we may end up with if you were to literally follow that through, with a room with a computer bank.
Yeah.
Let me back up to your second question. As far as I understand, there's no intention to build out a customer, base, individual subscriber base beyond the city limits of the two cities, which obviously incorporates the university and Savoy.
Oh, I wasn't concerned with that. I was just concerned with just the wording in there, in the event that there's anything that's done outside, I just wanted to make sure that you didn't leave out that there were pieces in the county for if there's any particular reason to include
apparently
them.
some of the rings go beyond city limits.
Yeah, and it just says this is the transition to it. That 9A2 has nothing to do with the build out. It's
Right.
From what I understand, it's just the transition, but it makes no mention of the pieces that are outside the corporate limits. And I don't know that they, I would think you'd want to include every piece in some fashion. Anyway, special meetings of the board, would those also be publicized and made open per the provisions in Section 5.1, the new Section 5.1?
The problem with special meetings is, where do you publish them? What does the notice look like? I think we've had that conversation a couple of times. Where do you publish them? What does the notice look like? What happens if there's a very, very minor defect in the notice? All of a sudden, what ends up happening is you begin to hamstring the not-for-profit. Not-for-profit will operate more efficiently than government. Government, by nature, is not efficient for good reason. But if this thing is going to be a competitive organization, with the Comcasts and the AT&Ts of the world, it can't wait to, have special meetings based on notice and publication. They will do their best.
Then outside their annual meeting, they could basically call every meeting a special meeting.
Well, they have regular meetings. The bylaws provide that there must be at least one meeting per quarter, and they are going to publish their meeting schedules on an annual basis of the regular and annual meeting. They can't publish in advance until the event triggering a special meeting occurs.
Well, if, let's say that for what, somehow the public does find out there's a special meeting, are they entitled to attend?
Yes.
Yeah, okay. So if they
Absolutely.
find out, if there is, if there's, basically, I don't need any special notice. You put it on the web, it's publicized in some standard fashion when possible, and as long as it's open.
Again, the bottom line is, who do you appoint, and will they carry out this particular interest? And I would hope they would. But there's nothing in the bylaws that say special meetings are going to be closed.
Okay.
The intent is that every meeting is open unless there's a statement on a particular matter as a reason for closing the meeting.
Okay, we have we have 3 members of the public that wanted to testify. Is there another question from you, Dennis? Or? Yeah. Okay.
Just really for a point of clarification. It talks about that the assets of UCTB will be either leased or licensed. What's the difference between those two actions? Is there a significant difference? How do you determine whether you're going to be leasing something or licensing?
A lease can be of a real estate interest. A license can be a non-exclusive license, for instance, to use a right-of-way. The problem is there's such a large collection of what we in the law call property rights, and historically they are delineated in 2 fashions. One, real property, which is real estate, and then personal property, which is everything that's not real estate. Given what's happened with technology these days, those definitions are not always that easy. I'll give you a simple example. The fiber. If it's above the ground and laying on the ground, it's personal property. Normally, applying normal concepts, traditional concepts of property law, when it's buried in the ground, it becomes a fixture. A fixture, like a house, is something which is so firmly affixed to the real estate as to become a part thereof, and therefore it becomes real property. When we get into intellectual property, that's generically personal property, but has a whole different set of issues related to it. When you buy Microsoft Word or some program for your computer, you don't get a lease for that, you get a license to use that. Maybe license to put it on 2, 3, 4 computers, but it is a software license as opposed to a lease.
So we'll be actually dealing with both kinds of, we'll be actually working with both kinds of...
And probably, we also have public right-of-ways that we're going to be dealing with. And then we're going to have contract rights. And we're going to have subscription rights. And we're going to have IRU rights. So there's going to be a whole collection of rights. And to try to anticipate every possible right, seeing that this is obviously a developing area both technologically and in the law, sometimes being less definitive is better, because it gives the concept an opportunity to grow with technology, and in this case, with the law.
Okay, thanks.
Okay, thank you very much.
Thank you.
Pete Resnick.
Good evening. You'll bear with me going in the opposite direction. I share the mayor and alderperson's jet lag. I just got back on Saturday night myself from Europe, so I'm a little bleary-eyed. So, as most of you probably know, I've been in favor of making this next step in the transition more like a publicly owned utility or otherwise, but I've become convinced that the not-for-profit move that we're making now is a perfectly reasonable compromise. And as I've said before, the particular legal structure isn't nearly as important as eventual public ownership of that asset that we put in the ground. I think that what we've got on the table goes a long way toward doing that. I wanted to express a couple of concerns I've got with the IGA and with the bylaws. Although none of these are earth-shattering, I think this is going exactly on the right path, and especially now that we've got in the mission statement that this is for the public interest, I think that really says in the bylaws that the consortium is going to work toward that. Anything that ends up in the bylaws requires 2/3 of the board to amend, and I believe plus it must be one member of each of the entities. So once it's in the bylaws, I'm not really all that concerned. I think that's a reasonable level of interaction that we can say, this is what you need to do, and if they collectively decide to change the bylaws, I think that's fine. The strange thing about this setup is that you are creating a business where you are not the owner as it normally would be in bylaws. Normally, if I were to set up a corporation, I would create these bylaws so that folks who come after me would be able to follow them. You're creating bylaws that you're sort of giving to another group of people and saying, here's what we want you to do with this new corporation. So I think it's important for you to get as much into those bylaws as reasonable without, as Mr. Simon said, hamstringing them. So, with regard to the IGA, the last copy of the IGA I saw still has the idea of transferring rights in the definition of transfer. And down in the body in 9A1 and 9A3, it still uses the term transfer, where what it means is license or lease. I'm a little concerned about the confusion that causes because the word transfer gets used, not capitalized, elsewhere in the IGA, and to a certain extent, I'd like it to be really clear. The words license or lease don't appear in Section 9A, and I really think they should, to make it clear that what we're doing is licensing or leasing these assets to the new NFP. The other thing that's interesting is the IGA currently doesn't describe how board appointments work. Those are all in the bylaws. There are references to appointments of the board, but it doesn't actually say how appointments to the board are made in the IGA. I think it's probably important to mention that. The other thing I would say is I don't have a big commitment one way or the other. I think Champaign would make a fine trustee. I think Urbana should consider whether they want to be the trustee for the assets in the end. I have an affection for Urbana, so. With regard to the bylaws, most of the concerns I have are cleanup, and so these are probably for Mr. Simon. I noticed that at least, again, the last version I saw in Section 416, it refers to IRUs and maintenance and operation for the city's networks. But, of course, if the city still owns the property, there won't be an IRU back from the NFP to the cities. And I take it this is just leftover from when it was in its earlier version.
You have 1 minute.
431 refers to amending the way that certain things are handled, but of course that section is no longer amendable, so that probably needs to be cleaned up. Similarly, 11.2, which is the part of the bylaws that says that things can't be amended, doesn't say that itself can't be amended, and should probably be included on that list. Finally, with regard to open meetings, I think other people will be speaking to this. I am convinced that it does not need to be following the Open Meetings Act by any means, but giving some guidance I think is useful. I think the non-discrimination in hiring stuff is a very good addition to the bylaws, and I think everything else I have to say other people have already said, so thank you.
Thank you very much.
Pete, just to clarify, I'm looking at the top of page 3 of the IGA. Says transfer means the conveyance of rights to use and or access the system. In the case of other consortium assets, transfer means the alienation or assignment of such rights or liabilities as the case may be.
Right. So now, if you look at 9.9A1 and 9A3, it refers to transfer of the system twice. So there, I take it it's talking about licensing or leasing, but that's never mentioned. And it means the conveyance of those rights, not the actual physical transfer of the assets. I found it a bit confusing. Maybe legally speaking, it's reasonable, but it doesn't really speak to that idea of leasing it to the NFP.
I don't know if you have the latest
I may
draft
not.
where we, in the definition section, define the word transfer.
That's what I just read him.
Yeah, okay.
But it doesn't mention licensing or leasing
That's right,
in there.
because there may be other types of transfers which are not licenses or leases. For instance, there may be an assignment of rights. Assignment is not a lease. For instance, subscriptions to the system to transfer those would not be by license or lease, they'd be by assignment. There are certain liabilities that would also be, quote, transferred. That would be assignments. Contracts that currently exist, they involve rights, but they also involve, as do subscription agreements, obligations. And one of the things that all three entities want to be able to do is transfer future liabilities for this system to the not-for-profit, thereby providing a shield or coverage for those liabilities, which would be picked up by the not-for-profit. So that's why it's not specifically described. Now, in terms of the legal document overall, there's reference, as you indicated, to capital T transfer, and I'd better not use this expression, lowercase transfer. In any event, where it's in lowercase, it's not a defined term.
Got it.
And so it's where it's capitalized, then you refer back. Any capitalized term should be in the agreement. Hopefully it's been picked up, a capital or a defined term.
Thank you very much.
Thank you.
I appreciate the work that you did on the board too.
Thanks.
Danielle Chenoweth. And welcome back to you.
Thank you. Hopefully Ezra will stay in the hallway long enough for me to get 5 minutes in. Danielle Chenoweth, 412 West Illinois Street. I learned the hard way on council something. My 7 years on council, I learned that it actually doesn't matter what the News Gazette says. It doesn't matter what people say in these meetings. What matters is in the document. So I want to talk to you about what is in your documents. And you have this in front of you. I circulated, it's a little dog-eared because I don't have staples at home. There's a 3-page document, and I make very specific recommendations to the language, which actually reflect almost everything that has been said here. So the attorney has given you specific advice and interpretation. I would like to see that codified in the documents, because at some point, you may be gone, you may be gone, the mayor may be gone, we might all be gone, but the documents exist. So starting with the IGA, there's two pieces. It has been circulated that UCTB may be supported or will be supported by the cities for 6 months. If that's true, the document says September 30th. So I think it's important to make it clear, partly because I think as a business owner, I know that you can't just take something and change its financial structure overnight. It really needs a transition. Second in the IGA is Section 22B. I have concerns about it. Partly, so what Mr. Simon has said tonight is that the consortium, Champaign will be vested with the assets and will act on behalf of the consortium. But 22B actually says that Champaign would own the assets and the entities would meet and confer to determine how the assets can be best used for the community. That sounds great, but my question is, who's the decision maker? If it's the consortium, it's not clear in that sentence. So it sounds like Champaign's going to get your input, but Champaign doesn't need to take your input. That's how I read that document. So clarification would be good. So on to, and I also have questions. What's the legal structure of the trust? Is this a new entity? What does that look like? Does it exist on paper anywhere? So that's a question. With the bylaws, this, according to the current revised language, so this is the language with all the revisions, the nonprofit could meet and vote in secret on the other side of the world. That is still true. The nonprofit technically could be open to the public, but as Ms. Amon said today, no one may know about it. So special meetings do not have to be noticed. So there can be an annual meeting, but essentially you can have a number of special meetings, and that's the easy way to get around the public. And unfortunately, we've seen that kind of thing before. So it's important to, even with bodies that are appointed, we've seen this situation before. The board could circulate a proposal in private. That proposal does not have to be public. That board does not have to have public input like we're having right now. So that appointed body could have that proposal, will not have the public input necessarily, and will make a decision without the benefit of that public input. The board could also close the meeting from the public for any reason, as long as they state that reason. There's no stipulation. And even if all of your appointees, every single one of them objects, they can still close that meeting, right? So this is a problem if for some reason that board is about to act not in the interests of the city of Urbana. You have not put into the bylaws yet to require that. So here's some suggested changes. I have very specific language. It does go with the spirit of what has been spoken about tonight. I strongly urge you to include these pieces in what you send to Champaign. So 441, 442, possession and title are still referred to. 51, this is the most important. If you don't do anything else, this generally is not okay. The meeting of the board of directors will be open to the public, held in Champaign County in a publicly accessible space, and will allow for public input. You need to include that in these bylaws. Otherwise, it's open meeting is just smoke and mirrors. You must require a 2/3 vote, including a member from each appointing entity. If it's the case that all the participants include the public, Charlie, it's got to say including members of the public. Why not put that in? Because they're not going to hear James's comments 5 years from now, okay? 5.6, all notices of all meetings, including time, place, and purpose, shall be made public. You have to stipulate that, otherwise it's not clear. Public, just put it on a website so that we can see it. It doesn't have to be a big deal. Public bodies do it all the time. We have dealt with emergencies before. The action by written consent should be struck. That's an easy way to get around public accountability. Who says it's an emergency? It doesn't stipulate, so they shouldn't be making decisions in writing. If they can get on the phone with each other in the case of an emergency, especially if you have the electronic meetings. Lastly, I want to say the committees, it's important that you stipulate from the beginning that the users and the anchors have some voice. So a standing committee of users and anchors, they can get rid of that if it's not useful to them, but why not start with that? Because that's what you have now, is you have community representation. And I would add, one of the weaknesses of the network is that it's not listening to its users and its anchors. That's one of the reasons the business model is struggling. And so by having that, you actually strengthen its business model. I'm sorry for going over time. Here's some very specific language. I'd like you to seriously consider this and make sure that you direct your attorney to get on the phone at 9 o'clock in the morning and make sure Champaign knows about those decisions so we don't have two different versions. Thank you for your time and for your service. It's very appreciated.
Okay. Thank you very much. Any questions for Danielle?
I just wanted to ask one question. I know you were a part of the granting process early on with UC2B, and that you've seen the business model and the nonprofit. Is it your understanding that under the nonprofit, the creation of a for-profit entity would actually be running the network? that hasn't been discussed here?
So, just looking at my reading, so there's a lot of different ways that networks are run. I've looked at a lot of those different models trying to find the best of breed. I don't think the best of breed has actually emerged yet, so we don't have like specific models. There's definitely networks that are viable. We talk all about the negative scenarios. There's a lot of great networks that are viable out there, and it seems like the model is very custom to the community. There is not a one-size-fits-all. So I think that's what we're grappling with, is what model is right for us. On the topic of if you have a 501c4, my understanding from that, and I'm not an attorney, although I'm a dropout law student, as you can tell, is that you can spin off a for-profit entity. That's the reason why it's a 501c4 and not a 501c3, is that you can have a for-profit entity operate the network. That would be up for the group. In some ways, the way I think about it is the public transparency and accountability piece will help to make sure that the whole voice of the community is included as we look at that. That may be the right approach. There might be a different approach that is the right approach. Who knows what Comcast and AT&T are going to do? Who knows how this network is going to evolve? But if we, the public, can participate, and I've been in this issue for 15 years, well before this UC2B started, and we have a huge brain trust to some of the people in the audience. We want to make sure that all of these people are included in this process because they have a lot of knowledge to bring to the table beyond those 9 people. So the answer to your question is, I don't know what the right solution is. I do know that a for-profit entity could be a spin-off, but what's important that you do is that you set the platform for all of us to participate in the brain trust of building this network and helping to guide it to be successful.
Thanks.
Thank you very much.
Thanks.
Peter Folk.
Hi all, Peter Folk, 1407 South Maple Street, Urbana, Illinois. I have been very happy to see the progress that's been made on this document. It's definitely, or the 2 documents, they've definitely improved to a state where if they were passed as is, the world probably wouldn't end. So that's a change, I would say, from the original versions of them. I had a few issues that were either overlooked or perhaps didn't make it in that I wanted to emphasize. I also want to point back at Danielle and Pete as spot on. Those are exactly the issues that I hope that you will direct your attorneys to insist on. Every single one of their points was, except I kind of got lost with Pete's, were very good. And I'm sure the ones I got lost on were good too. The specific items I wanted to point out, the first is in the IGA. I'm one of your Cable Commission members, and one of the things we advise you on is the franchise agreements and that kind of thing. In the IGA, you'll note that you shall grant this NFP access to your rights of way. There's no limitation on that. There's no time limit on that. There's no reevaluation of that. It is a shall grant, and you don't get to put anything on that. That seems like an awfully big giveaway. As you know, the contract negotiations with Comcast, the franchise negotiations with Comcast are long, drawn-out affairs simply because you have that power of saying, well, that doesn't meet the minimum standard for providing our community with good service, so we're not going to grant that. I would strongly recommend you put you provide yourself with some ability to reevaluate that grant every 10 years, for example, as your franchises are. Second of all is as you know, the network was created as an open access network. Terry mentioned that's pointed at in a lot of places, but none of those places are actually in the bylaws. None of those places are sections that cannot be changed, with the one exception of 4. 4.1.1, where it says this fiber optics ring constructed as an open network. One of the guiding principles of this network is its openness. And in specific, in the business plan, there is a section called Guiding Principles with some great language in there that was some hard-won language back a year or so ago. And it says that one of the core guiding principles of the network is to provide an open, facilities-based, neutral network that serves as a level playing field for all network and service providers for both physical and logical network services. That seems to me like it should go in Section 1, where you're giving the core purposes of the network, and it also should go in Section 4.1.1, where you are defining the operation, how the network will be operated. Another fairly minor issue, probably not intended, but you'll note that the withdrawal from the NFP can happen simply by your inaction. If somehow you neglect, if the mayor somehow is on vacation for 30 days and neglects to reappoint someone after a vacancy happens, you lose that seat. You even if you only don't appoint one, you've indicated that you have withdrawn from the NFP, and there's no way to get back in unless the members invite you back in. I'd recommend you look into eliminating that loophole. Go ahead.
Yeah. Don't people normally serve until their replacement is appointed? So can you fix that if there's a problem?
I didn't hear the last part of your question.
Can we fix that if there is a problem as...
I don't perceive there's a problem because there's the withdrawal is after 30-day inaction. There's a vacancy. In other words, if somebody resigns, an individual resigns from the board. Let's say it's one of our appointees. We have 30 days in which to appoint somebody to fill that vacancy. The presumption is, because there are our 3 appointments, we would fill that vacancy within 30 days.
And if the mayor's on vacation, there's always the mayor pro tem.
Of course.
And the mayor's usually not gone for 30 days. But anyway.
It just seems like a fairly dangerous position to be in, where something could slip through the cracks, and by inaction you would permanently be out of the NFP. Which, again, you can read it, and just providing my understanding of it. Again, not being even a dropout law student.
Can I just ask for a clarification for 1 second? We have, under some circumstances, we do have boards and commissions that have openings that remain longer than 30 days. And in this case, if we had a position that remained open longer than 30 days, then we would just simply be out of the NFP?
I can bring it up to University of Illinois and Champaign Council to beef up that provision. In terms of the open access, I think 4.11 takes care of your concerns that this is an open access network. The other thing is the grant provided for it to be open access. Our application for approval of this structure has to be approved by NTIA, and if we change access to the assets, which would affect the government's interest in the assets, we have to receive approval. And I don't know what the government would do, but my guess is they would not favor a closed access system.
The history of telecommunications is rife with open access networks in name only. The telephone system right now is an open access network, but you'd be surprised about it.
I think my only comment is what Fred Stavens at Champaign repeatedly says. We can provide anything we want in these bylaws. We can provide every other page that this shall be an open access network, and if the 9 appointees wish to ignore that, somebody would have to bring an action to compel dissolution, involuntary dissolution of the not-for-profit for violating its bylaws. Again, bottom line, always with any organization, it's only as strong as the people that are selected to manage it.
I guess I would go back to Danielle and say that your bylaws are the things that survive, and having as much strength in them, as much guidance in them as possible is a good practice in not-for-profit entities especially. One last note, I strongly support the public notice on the website of all meetings, both emergency and non. Of course, if the public can't make it, then that's their problem, but if you don't notice it. And second of all, Danielle also mentioned that agendas and minutes need to be public as part of that. Those are key components of transparency. So I'm happy to answer other questions, but
okay, thanks. Any questions for Peter? All right, thank you very much. And two people don't want to speak, but they want to be registered as favoring Monica Carr, 210 West Vine Street in Champaign, wants public ownership to be retained, the network operation to be open, and public meetings, the continued operation to bridge the digital divide and stimulate job creation and retain public ownership. And then Jeffrey Putney of 126 Church Street in Champaign also does not wish to speak, but he wants public ownership of the network and owner actions requiring public meetings. Okay.
Okay, I have a real simple question.
Okay. Carol Emmons.
If we can put anything we want in the bylaws at this point, and they can change them when they want, what is your objection from Urbana's side to just putting in the recommendations as they've been listed here in the documents that we have?
As your counsel, will take your direction. I will caution you several things. One, this is not a monopoly. And if you start requiring, for instance, always open meetings, AT&T, Comcast can come in and sit in on your meetings. And they're one step ahead of you because they can react to whatever happens in any of those meetings a lot faster, at least initially, than this not-for-profit board, because that's what they do. They can come in, they know what the pricing structure is, they know what the concept of the pricing structure is, and they can come in and engage in predatory pricing if they want to. They will lowball this area for 2 years, knowing that other areas will support their pricing structure, and it will not impact them one iota, but it'll drive this not-for-profit out of business because it won't be able to compete for those 2 years, and therefore it's out of business. You can load up all kinds of process that requires the board to take steps that an efficient board does not. I have in the past represented a number of not-for-profits, local not-for-profits, national not-for-profits, and international not-for-profits. And they do not operate like a government. They operate like a corporation.
So what keeps them from doing that currently? If we take the non-for-profit off the table right now and we continue as a consortium, what keeps them from doing the lowballing now? They can do it currently.
They can do it now, but one of the problems is University of Illinois doesn't want to operate the system.
Well, I
don't
get that
know what
part.
Champaign wants to do,
No,
and that's a reality.
I think my question is a little different. So I understand that you don't want to put your prices out like Walmart and Target. I get that part. But what I'm suggesting is that open access doesn't necessarily just mean in the purpose statement. The activities around it should also represent open access. And I'm concerned that there's a push to put it in writing, but not necessarily to do it. And some of these that are recommended are simple protections, I believe, for the cities and their investment. And what I keep hearing being urged is the lack of protection on the side of the cities and opening up the process so that you can close it.
There are provisions in there. Obviously, as I've indicated, we can put any, as I said before, we can put anything we want in there, and if the appointees choose not to follow it, they have no accountability until their appointment runs out. The presumption is open meetings. the presumption is to close a portion of the meeting, there has to be a statement. There will be, the bylaws provide for an annual report to the board, the not-for-profit board, and an annual report for publication for the public. There is nothing to say that this city, that Urbana, cannot, as a condition of its appointees, require its appointees to make periodic, every quarter, every 6 months, once a year, however you want, once a month if you want, reports on the status of UC2B to the council. There is no conditions placed on who we can appoint or the conditions other than within the bylaws that we appoint 3 people and they serve their terms until their successors are appointed, or if somebody decides to resign, we appoint a replacement for that resigning. But we can put conditions if we want that our appointees have to report to this council as frequently as the council wants. Again, all of these comments, I appreciate these comments, and if that's what the council's wishes are, I will go back to, I would need a list of every one of the comments, all the different kinds of comments, some of which are conflicting within the present public presentations. So I don't even know, wouldn't know how to act in that response, but if the council gives me a list, I will gladly go back to U of I and Champaign's council and say, here's what Urbana wants. I will also probably strongly suspect that some will be accepted and some will not be accepted, and now we're up against a deadline, and I don't think we want to miss the October or the August 15 deadline. I mean, that's what we're up against. We have 10 days to finalize this agreement.
Bill Brown.
I'm pretty excited about this, actually, the next step in this transition. I think one of the frustrating things for the current grant to me was that it was kind of limiting to which underserved populations we were serving. For an example, nothing south of Illinois Street in Urbana is considered underserved, but we all know there are underserved populations south of Illinois Street. So hopefully this new nonprofit won't have the same geographic limitations that the grant did. So I did have a couple concerns. I think mainly the public notice on of special meetings. There's no notice required except to directors for special meetings. So theoretically, 2 people could sit down in a coffee shop, decide to have a special meeting, call up 3 other people, and they'd have a quorum. So I think if you had a special meeting, you should at least post it on the website. If you're going to have a special meeting, maybe 3-hour notice would be reasonable, or 24-hour notice. But maybe something. And lacking that, at least maybe, as Danielle mentioned, having minutes and agendas available, so that even if they did have a special meeting, even though it was open and nobody came except the 5 directors that constitute a quorum, they would still have to post their minutes so that we would know what happened and have some public control that way to at least let them know afterwards what we disagreed with if they did something wrong. I mean, I don't think there's going to be a rogue board that would do this, but it makes sense to consider some of these things. I think most of the other things that were my concern were covered. I know there's been some mention of community benefit fund. So hopefully if there's a profit corporate, my idea of how this is going to work would be if there was a for-profit corporation that would start generating a profit for the nonprofit, they would reinvest that in a community benefit fund or something, and then you'd be able to serve these underserved communities that we can't serve right now to meet the objectives of the corporation. So I don't see too many problems with this really, except I would like to see the public notice of special meetings strengthened if possible, or something along that line. Other than that, I think it's pretty good.
Okay, Eric?
I think I'm persuaded by Jim's argument that this is an entity that Comcast or other AT&T could consider a competitor, and that we don't really want the public, we don't really want the public accessibility of the meetings to be turned to private gain on the part of the competition. So I think I've been converted to that view. I also had a concern that Danielle also raised about Section 22B and about the ambiguity about who in fact is the decision maker on disposition of the assets. And I wondered if Jim, you might enter into, and if the council agrees, that you might try to negotiate a change in wording and say the entities would decide how the assets would be distributed for the good of the community, just to make it absolutely clear that it is the governing board and not the city of Champaign or the city of Champaign members who would actually make the final decision.
If we have that unfortunate experience and the assets come back, and this will, to a certain degree, address Danielle, there is no trust agreement. She is correct. To create a trust agreement for something that may occur at this point or 50 years from now may be difficult. Theoretically could be done, I imagine. Lawyers do it all the time with estate plans. However, Champaign is obligated as a trustee by agreement to hold the assets in trust for the three entities, one of which, of course, is Champaign, but certainly the other two are University and Urbana. That means Champaign cannot dispose of those assets with, in an improper way without violating the fiduciary duties imposed on a trustee. I'm not sure, and that's up to you all, that Urbana, when you really start thinking about what kinds of responsibilities run with being a trustee, I'm not sure Urbana would want that, because one of the things would be the financial, at least fronting the financial aspect of being a trustee, which could be millions of dollars until some decision is made to dispose of the assets. Plus, the trustee incurs all the liabilities of managing the assets coming back, such as they are. And remember, if this were to occur, they would be coming back from a failed effort. As your counsel, if you were to ask me, should Urbana become trustee of this thing, my legal advice would be run as fast as you can away. Because you don't know what you're getting into, and you can never know until it happens.
Right.
Okay. Charlie.
I fought for many of the items that Danielle has restated here last week. I think many of those were met in the changes that were made in the document on the 31st. There are two small items that to me are critical to my support of this, and I hope to get a majority of you to agree. I think these are so small that they can be communicated and changed. And so 5.1b currently set, let me switch to the right document here, sorry. 5.1b.
Which document are you looking at?
The bylaws, okay. 5.1b says, generally, the meetings of the Board of Directors shall be open to the public. I think we need to add, and will allow for public input. And I would move that we include that language in this document. That's a motion.
Is there a second?
Yeah, I'll do that.
Okay, there's a motion and a second to add that phrase.
No.
Eric.
So what is the intent of the motion? Is the intent of the motion to direct our council to attempt to negotiate that, or will we actually not enter into the agreement if it's not there?
I think we make these attempts, and then we, in the ordinance that we pass, if we pass it tonight, gives the mayor the discretion to move forward. So I think she would eventually be the judge of whether we've, I think these changes are so small that they would not be objected to by Champaign and the university. That's what my goal is that I think these were intent of the majority at the meeting last week from both councils, and I don't think they're reflected in the changes. I think the intent last week was to allow for public input in these open meetings.
I've heard 5.1b regarding that the meeting shall be generally open, and you would want the language "and will allow for public input."
Yes,
All right.
yeah, so
but you're referring to multiple changes, so I've heard one.
That's one. That's just, I'm going to do one. I'll do one now, and then I'll do one more here. I'll do separate motions here.
Okay, Carol.
I just want to ask you a question because I think part of the argument last week about this particular issue is not to make the meetings necessarily in Champaign County, which is what was presented from Danielle's right of this. And if the meeting is in wherever, normally people would not make it to that meeting, right? So to put a public input section into a meeting that might be in Las Vegas, unless you stipulate where the meeting is going to be, I don't know how useful that will be.
Yeah, well, I think if they go off on a jaunt to somewhere, and I was more or less convinced last week that there are legitimate reasons to say go off to, visit with a vendor somewhere, I mean, they went, and I got beat up on that one last week.
I was with you, okay.
So I got beat up on that one. I don't want to touch that, but at least,
I do want to clarify
even if
something.
they are meeting in New York City or in Timbuktu, a reporter can travel with them and report on it, and if somebody really wants to make a statement, they can be there and make, in general, the meetings are going to be here. They're going to be open to the public. They might as well allow for public input.
I certainly don't necessarily disagree with you on that. I just wanted to clarify that the board who's going to somewhat oversee won't necessarily be the executive director who's going to be operating the day-to-day operations. And I think there's a commingling of those two things, as if there's not going to be a day-to-day executive director that's going to take care of the business and travel to the conference and whatever. This board is supposed to look out for the public interest, which, so setting up parameters that the whole board is going to travel off to China, as they said last week.
I know.
It's not realistic.
I totally agree there. And, so anyway, my thought was at least, if we're going to have open meetings, that's the general sense, and then have public, might as well state we'll allow for public input, just at least that minimal language.
Okay, Paul Hickson asked to speak. Do you have anything new to say, or just to reinforce what other people said? Okay, I understand that, but does it relate to this motion?
I don't believe it does.
Okay. Well, let's do the motion first and then let him talk.
Let's
Okay, so there's a motion on the floor by Charlie, seconded by Dennis. Any other discussion?
Yeah, I have a question.
Okay.
And I just want to ask, we're talking about the 4 meetings of the board of directors. That's
at
all.
least those.
It's
at
very
least
simple.
those, yeah,
We're
at
not
least
talking
those.
about 25 meetings. We're talking about just 4
Well, at
quarterly
least
meetings.
those or any others that are open meetings. Basically, all their open meetings. And they can create the rules for public input, but they're going to allow public input.
Okay. All those in favor, please signify by saying aye.
Aye. Aye.
Those opposed? That motion carries. Paul Hickson, would you like to say something?
Thank you, Mayor and Council. My name is Paul Hickson. I reside at 209 West Indiana. I've lived in Urbana for 43 years. I've, for that same time, worked at the university for 43 years, and I currently am the Chief Information Officer for the university. So nominally head of sites, and have been involved with the UC2B project in some way before I got to my current role, because formerly I was in the College of Agriculture, Consumer, and Environmental Sciences. I would like to ask, as you consider the matters tonight, and I'll be brief, but my bottom line is for you to do exactly what Charlie was doing. Throw as little in the way of this as you can philosophically square with your duties, because and follow what I heard as the advice of your counsel, and move to approve the document that has been not only worked out together by the three parties, but what I'd like to step just back a little bit on is, why did we do this? And I knew Mike Smeltzer before he got involved in this. I worked with Joanne Hovis when she was an early consultant. And the goal all along is so consistent with the Chancellor's goal of leveraging the intellectual capacity and strengths and IT capacity of this university and this community to help grow the community. Resolving digital divide issues is terribly important to the campus. It's important to me personally, but it's not the sole function of this. And the role of IT in advancing the economy of the region, of developing more jobs, of creating a future that we want economically, we want in terms of employment opportunities, is essential. It's complicated. And there is a ticking timetable here. And so keeping that big eye on the eye on that big prize, I would ask you, as a not as a university person, I was mentioning that just so you'll know who I am, and not to hide anything. Yes, I have a long history in this, but I'm really speaking more as an Urbana resident, and asking the people that govern my city, this is a historic moment. Please act in a way that will advance the formation of this entity so that this community can advance. Thank you.
Thank you. Okay. Any other changes? Charlie?
Yeah, so the other very small change, and a little bit more complicated, but is also in the same section, 51C. I tried to get the 2/3 vote, including a member of each appointing entity, last week, and it didn't fly. So what I would propose is something like this, and I'll make a motion that we do 51C, adding after the statement, for closing the meeting or portion thereof, comma, is done by majority vote, comma, but includes at least one member from each appointing entity. So if I could speak to that. So what I'm saying is that a majority vote is sufficient to go into closed session, but it includes at least one member from each from each appointing entity. So it could be 5 people, but at least the three of the.
Okay, motion by Charlie, seconded by Carol. Any discussion? All those in favor, please signify by saying aye.
Aye. Aye.
Those opposed? That motion carries. Carol.
Also, last week, we wanted to recommend the striking of the waiver of notice which is 5.7, so I move to strike the waiver of notice. I think notice should be given for the meetings as Dennis just illustrated so that people could attend if they so chose. But the striking of the waiver of notice, I would move to strike that from the agreement altogether.
Which section is that again?
That's 5.7. It's 5.7, and Charlie just seconded, and Diane has a question.
Diane.
What is the rationale for that?
If you're going to have publicly noticed
No,
meetings.
I'm asking.
Oh, you
what-
was asking him.
I'm asking what the rationale is for
Oh, okay,
the
thank you.
language that's in here.
The rationale of the language is, and the latest, if you're referring to the section I think you're referring to, is there are instances where there may be an emergency and an advance notice may not be operative, it may not work. My example is a node blows out. It has to be repaired now, and the executive director feels that he or she does not have the authority to take that action without board approval. So you have a notice of meeting and you wait a day or 2 or 3 to repair it. Now, granted, maybe the executive director is willing to take such action and the chairman is willing to approve such action on the hopes the board comes back and ratifies that action. But if the board doesn't ratify that action, then you have a problem. The provision in the latest draft suggests that there must be an emergency for waiving such a notice, if we're talking about the same section. You didn't make a section reference here.
Charlie. Just
let him finish. Oh,
I think.
are you going to say something?
Yeah, I was just going to ask him a question.
Okay. Go ahead.
I was just going to clarify. The emergency is in the language. If there's an emergency, that there is a response to that emergency. But in this case, this is a little different because a node or the operation of the system is a little different than the noticing of the 4 meetings that are the quarterly meetings that should be public anyway. And so to give them the right to waive those notices, I think should just simply be struck because they already have a response to emergencies written in there.
As I'm reading section 5.7, it seems inconsistent with itself. Well, it's inconsistent with itself because it talks about waiving a notice before or after a meeting, and it doesn't provide for that. My suggestion, make a clarifying motion, and I'll bring it up to the other 2 council. No guarantees that they're going to accept any of these changes, and then I guess the mayor's going to have to decide whether she wants to sign the agreement.
I mean, we did.
I
make
will
a
talk
motion,
with council members before I decide.
But I made the motion to strike it, and Charlie
Strike
seconded.
5.7
Yeah,
altogether.
because it's inconsistent with the other part of the document.
Okay, any discussion? Bill?
I just wonder if that's to avoid a technical situation where, it says they're talking about notice to directors, not to the public, I think. So if you have a meeting, they're saying if you came to the meeting that you waive your notice. So that
if you've come to there's a provision, if you've come to the meeting, you waive your objection to notice, because obviously if you show up, you know that there's a meeting.
No, I think that's all it's saying.
Well, yeah.
Eric?
So I'm wondering if one thing to do with 5.7, I mean, I would agree with striking either before or after such meeting has been held. That doesn't make logical sense unless you have a time machine.
If it's merely a director, a director who shows up at a meeting and didn't get a notice, unless the director's objecting to the meeting itself, it's kind of like in litigation where somebody shows up in court and says, "I object to the jurisdiction of this court." And one would say, "Well, but you're here. How can you object? You've asked me to do something. How can you object to me doing anything?" It's that kind of provision. It's kind of chicken and the egg provision.
Suppose
It
we...
probably should be a little bit clarified.
Yeah. Suppose we could, I don't know exact wording, but I wonder if also between any and meeting should insert special meeting. I think one of the concerns that's been raised is that this waiver of notice, if we had an evil board, this waiver of notice could apply to the quarterly meeting.
Well, it does say any meeting. I don't know. I mean, I would assume that a special meeting is an any meeting.
Yeah, but the quarterly meeting of the Board of Directors is also any meeting. So as I see
Well,
it...
that's why I tend to agree with Carol that this needs, I don't know about any, but it needs to be clarified. I think the intent of this provision is not to avoid public notice of a meeting. It's to avoid the situation where if a director does not happen to receive a notice and he or she attends the meeting, other than to object, claiming that this meeting is not duly constituted, that by showing up and participating, they've waived in essence, their right to object. But I think Carol is right. It needs to be clarified for that purpose.
So if we simply direct you to negotiate some clarification of this,
I'll do it.
And I for one am willing to trust you with that.
Yeah. Well, I mean, if you all approve the motion, then clearly I mandated to do that.
It would have to be amended because the motion right now says to eliminate it. So you want to say
So
clarify it?
I can withdraw my motion. You can strike or clarify this.
Okay.
So that it is not
Is that okay with your?
contradictory.
I guess that's okay with your
Just
second
seconded.
since he suggested it.
Okay.
Okay, we have to either strike or clarify. All those in favor, please signify by saying aye.
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 Those opposed? That motion carries. Anybody have anything else? You ready to act on the modified? Okay, Jim, Simon.
May I make a suggestion that
Sure.
somebody might also want to move, and I don't have the authority to move, changing or modifying 4.3.1, which was brought up by a member of the public, indicating that if somehow something slips through the cracks in 30 days, we've automatically withdrawn. What I would suggest is, one, making it a 60-day, and two, providing that the not-for-profit, somebody, either the executive director or the president or somebody on behalf of the not-for-profit, provide written notice to the appointing entity that has failed to make the appointment. That way, even if it slips through the cracks, there will be a written notice, and the appointing entity will either react or it won't.
So
Charlie?
moved.
Yeah, Charlie makes that motion. Is there a second?
Second. I'll second.
Seconded by Carol. All right, any discussion on that one?
No, but can we make one more recommendation?
Yeah, you can make, on this particular section? Or, oh no, we're doing them one at a time. Okay, all those in favor, please signify by saying aye.
Aye.
Those opposed? Okay, we got that one. You have another one, Carol?
Just one question to Jim about the page 8 interim funding part. The startup fund only going through September 30th. If your deadline is September 30th, how could that be a startup fund? And what should we do on extending that 6 months as recommended?
I believe
Diane.
that.
Sorry.
I think there's a confusion between the startup period and then what's defined as the transition period on the next page, and that does go for 6 months, starting July 1st, 2013, and ending the later of or 6 months after formation of the NFP. So it's through January 31st of 2014.
So that includes the funding part.
Well, I think there's a confusion here on everyone's part. Section 9 is a provision that is carried over from at least the first amended intergovernmental agreement and maybe the original intergovernmental agreement. And that's what this relates to. This relates to the consortium, not the not-for-profit, not the transition. The entire agreement, with some modifications to make it consistent with use of terms, is pretty much retained, as I say, except for the 9A and some of these other provisions relating to the not-for-profit and appointments and all.
So does that mean that the cities and the university would continue the funding, the initial funding budget part after September 30th through January?
Any obligations to be imposed on Urbana, Champaign, and the university are governed by the intergovernmental agreement, not by these bylaws.
Right. So did I miss that in the IGA then?
The IGA is the...
No. What
Oh.
I'm saying, did I miss the complete transition? I don't see the funding and how it would work in the IGA. Just point me to the section.
It would be Section 9A. 9A1, I believe the transition period is defined as beginning July 1, 2013, and ending the later of January 31, 2014, or 6 months after the formation of the not-for-profit, and the transfer of the system. And that's some language that's being changed because of defining transfer, and other consortium assets by UC2B to the not-for-profit.
So that includes that budget part of it.
Section 9 relates to the consortium.
Charlie?
I'd like to move ordinance approving, authorizing, entering into, and executing a second amended and restated intergovernmental agreement providing for the creation of the Urbana-Champaign Big Broadband Consortium.
Second.
Okay, motion by Charlie, seconded by Dennis. Any other discussion?
If I could speak to it. Oh. The big issue here, of course, is that Section 2 allows the mayor to enter into this agreement on our behalf. And so the changes we've requested tonight, we entrust to her, I believe.
I circulated, just before the meeting began, a draft ordinance instead of the one that's in the council packet, in anticipation that there might be these recommended changes. And if you notice, it says that the mayor has the authority to sign the agreement in a form that substantially complies with actually the draft that I sent out at roughly 5:30 this evening. Now, I've got my marching orders, and I will march, and I hope that I am successful. In fact, when I'm done with the meeting tonight, I will send an email to the other two attorneys advising them what you all have recommended and asked for changes. Again, I assume, and correct me if I'm wrong, that if I am not successful, if I am rejected by the other two attorneys, that the mayor will consult you about that. I will advise the mayor tomorrow, and will consult you about that, and then you all will decide whether she informally, poll, I guess, has the authority. Don't forget, we do have an Open Meetings Act issue, and serial emails aren't going to avoid the Open Meetings Act.
I'm well aware of that.
You what?
I'm well aware of that.
I know.
Okay, we haven't voted on it yet, have we?
We should, though.
Okay, do you want to have a roll call vote?
Yeah.
Okay, would the clerk please call the roll?
Alderperson Ammons?
Yes.
Brown?
Yes.
Jacobson?
Yes.
Madigan?
Yes.
Marlin?
Yes.
Roberts?
Yes.
Smythe?
Yes.
That motion carries. Thank you all very much. Okay, let's go back to the agenda. I skipped reports of officers. Are there any reports of officers?
They all left.
Okay, I will make a very brief report. We have, starting on August 12th, we have Rich Henschel, who has been finance officer, budget manager, and acting controller for Lake County, which has a budget of $500 million. coming in to be an interim comptroller. He also worked for the city of Bloomington more recently, and they were very pleased with his work. So we're doing our filling in of the vacancies that we have. Thought you'd like to know that.
Is he here?
He's going to be here on August 12th. Okay, that's my report. And then the next item was mayoral reappointment. Civil Service Commission, I'd like to reappoint Willard Broom.
So moved.
I'll second.
Okay, motion by Smythe, seconded by Ammons. Any discussion? All those in favor, please signify by saying aye.
Aye.
Those opposed? That motion carries. Thank you very much. There being no further business, this meeting is adjourned. Thank you.